Be seated.
We will hear argument first this morning in Case 21-707, Students for Fair Admissions versus the University of North Carolina. Mr. Strawbridge.
Mr. Chief Justice, and may it please the Court. Racial classifications are wrong. That principle was enshrined in our law at great cost following the Civil War. A century of resistance to race neutrality followed, but this Court's landmark decision in Brown finally and firmly rejected the view that racial classifications have any role to play in providing educational opportunities. Since then, the Court has broadly enforced the Constitution's prohibition on the use of racial classifications. Whatever factors the government may use in deciding which jurors to sit, who you may marry, or which primary schools our children can attend, skin color is not one of them. Grutter is a glaring exception to this rule. This Court should overrule it. First, Grutter is grievously wrong. Its view that the educational benefits of diversity justify racial classifications contradicts the 14th Amendment's guarantee of equal treatment. It relied upon stereotypical assumptions that race is necessarily a proxy for one's viewpoint, and its purported limits are empty and self-contradictory, which is why UNC simply ignores them. Grutter also creates many negative effects. Some applicants are incentivized to conceal their race. Others who were admitted on merit have their accomplishments diminished by assumptions that their race played a role in their admission. And there is no evidence that after 2 decades, Grutter has somehow reduced the role of race on campus. Finally, no one is actually relying on Grutter. The opinion forecast its own demise, and it made clear that race-based admissions must be diminishing over time, but that has not happened. UNC officials testified that they cannot imagine any scenario that would actually lead them to end their racial preferences. UNC claims license to use race in perpetuity, and the district court held that Grutter allows this. Racial classifications are wrong, and this court should overrule Grutter.
Mr. Strawbridge, the respondents argue that if you don't consider race, you won't be able to consider the whole person in the admissions process. How do you respond to that?
This court has always said that racial classifications are necessarily invidious, and certainly it is possible that an applicant, for example, could write something in which race provides a context for their experience, but just considering race and race alone is not consistent with the Constitution. It's also not consistent with other holistic approaches that this court takes. There's great freedom, for example, to strike a juror, but one thing you can't strike a juror for, in part, is their race. You can, in awarding child custody, the most holistic process perhaps known to law is the best interest of the child, but this court has held race cannot be one of the factors you analyze in deciding that.
Well, I understand that, but we're talking about an application to a university. If you don't include race, I assume that respondents think that by including race, it tells you something about a person. If you don't include that, then what do you include on the application?
Well, you include their experiences, you include where they grew up, you might include their socioeconomic status, you include all sorts of things that actually lead to broader diversity of viewpoints. The assumption that race necessarily informs something about anyone's qualifications is antithetical to this court's precedents and to our Constitution.
Can we stop a moment? And I want to break down what you're talking about. Sometimes race does correlate to some experiences and not others. If you're Black, you're more likely to be in an under-resourced school. You're more likely to be taught by teachers who are not as qualified as others. You're more likely to be viewed as having less academic potential. Even in your own arguments in your brief, you correlate race to lots of other things that are not necessarily causal, but which do correlate. How do you tease that out?
Well,
how do you want an admissions officer to say, I'm not going to look at the race of a child to see if they had all of those socioeconomic barriers present, and despite that they got very high school scores, maybe a little lower or a lot lower SAT scores, but I'm going to think about that You're asking them to just shunt it aside?
Yeah, racial classifications have always been disfavored for a number of reasons. They are necessarily divisive. They carry stigmatic harm.
So why is it that in the Reconstruction era, just when the 13th, 14th amendments were being passed, Congress spent a lot of money in trying to get black children, whether they were children of slaves or free slaves, to be educated in integrated schools? They had a belief, didn't they, that integration itself provided a value?
That is true. Of course, most of the Freedmen Bureau's activities are entirely consistent with this court's existing strict scrutiny rationale, even in the educational context, that remediation is an acceptable, compelling interest.
But that's only remediation for what? For slavery.
Well,
And these programs were made available to black free children,
well,
many of them.
well, and that's true. And also, the Freedmen Bureau.
And the Berea, Kentucky school that was supported by federal funds required a 50-50, 50 black percent children and 50 white percent children.
I'm not sure that the sources that are cited in the brief support that view. There was a desire to make the education at Berea open to all, but as far as we can tell, the actual policy was they did not make distinction among applicants by race. The only requirement from what we could tell is a willingness to actually be educated in an integrated and co-educational environment at Berea College.
So
Berea College, of course, was also a private school.
Now you're assuming in your argument that race is the only factor that gets someone in to a school. Could you point to any application? I thought under the Guter framework, you can't use race exclusively, but you can use it as one among many factors.
Yes, and obviously we have quarrels with the logic of that. In a zero-sum game like college admissions, if race is going to be encountered, that means some people are going to get in and some people are going to be excluded based on race.
But not the logic, the fact. What are the facts here about whether or not race is being used singularly to let people in?
The expert that UNC presented argued that 1.2% of the decisions were influenced by race. We obviously had disagreements with its characterization of that, but given the fact that they receive 40,000 applications a year, that's hundreds, if not thousands, of applicants who are being affected by race every year. Our expert's testimony was that race made the difference in basically 700 applications each admission cycle.
Was that
Counsel, I
accepted?
couldn't see from your briefs what your position was on race-neutral alternatives. Do you think those are appropriate, even if the intent of the state in adopting them is to reach a certain level of minority students?
Our position is that this court has an established framework that it applies to judge facially neutral governmental action that's alleged to be racially discriminatory. If the only reason to adopt a particular admissions policy, the sole exclusive reason, was for racial diversity alone, we think that would probably raise problems under that precedent, but of course it's a fact-intensive inquiry under Arlington Heights.
And I suppose, given that they're race neutral, most of them would not be defended as for race alone.
Well,
If, for example, socioeconomic status, maybe attendance at a particular school that's known to be
correct. All of the race-neutral alternatives, and specifically the socioeconomic benefits and the top percentage programs, those can be justified on race-neutral means. They increase socioeconomic diversity. They ensure that people at under-resourced schools have an opportunity to attend the university. They create geographic diversity.
Why is the question race alone? I mean, usually when we would look to permissible versus impermissible purposes, we would not say, well, it's only constitutionally impermissible if it's one thing alone. We would say if it's one thing at all, it infects a governmental action. So suppose that like there's a 10% plan or something like that, and part of the justification is socioeconomic diversity. And another part of the justification is we'll also get more racial diversity in this manner. And that's, you know, that's part of the purpose of the law. I think that that's pretty true to experience, that part of the reason that these kinds of plans have been developed is that people have understood that they will work to create more racially diverse campuses. Is that permissible?
Well, like I said, it's a different analysis when the mechanism that's chosen is not a racial classification itself. But I do think that
Well,
this
I
court's
guess the
precedents—
question is why is that true? A lot of our constitutional doctrine suggests that it's not a different analysis. In other words, one way you can offend the Constitution is by using an impermissible classification. Another way you can offend the Constitution is by devising a proxy mechanism with the purpose of using, of achieving the same results that the impermissible classification would.
Right.
So the question, I suppose, is why, I took your answer, which I welcome, to be yes, of course the 10% plans are constitutional. But I guess I wonder why, given most of our constitutional doctrine, that would be so.
Well, I'm not so sure that's the current state of the law, especially with City of Arlington. I think under Mount Healthy and its precedent, if the government can demonstrate that it would have adopted the facially neutral program anyway, then I don't think that there's liability for intentional racial discrimination in that case.
So if you prevail here, let's say, and a university develops 3 race-neutral alternatives to consider in the wake of a decision here, and they choose the one that's going to lead to the highest number of African American students, and they choose that race-neutral alternative for that reason. Is that okay?
If that was the only reason that they were choosing it, I think that would require, obviously, an analysis of what the evidence that was brought to bear in an Arlington Heights analysis. There's burden shifting that
What
occurs
if it's
there.
one of the reasons?
Well, I think if they can demonstrate they would have pursued that policy anyway, I think it's sufficient for them to escape liability.
Well, that really means it's not the reason at all. So you are saying if that contributes at all to the decision making, then that's impermissible.
No, I don't think that's what I'm saying. I'm saying that if the only reason to do it is through the narrow lens of race, and there is no other race-neutral justification for it, that the government can come forward and demonstrate that would have led it to adopt that policy anyway, I think that's the only scenario where it would create problems.
But isn't that what this plan in UNC already does? Race is never the determinative factor. That was a finding by the district court. Race alone doesn't account for why someone's admitted or not admitted. There's always a confluence of reasons. There are any number of Hispanics, Blacks, Native Americans who are not chosen by schools. So I'm not sure I understand how you're differentiating your answer.
Well,
If race is only one among many factors, how can you ever prove, given that the district court found against you, that it's ever a determinative factor?
I don't think there was a finding from the district court that it was never a determinative factor in any case.
Well, what it found is you hadn't proved it was.
No, I think the court acknowledged that race has an influence on 1.2% of in-state decisions and 5.2% of out-of-state decisions. Now, I think the court went out of its way to not specify in greater detail just how many of those were decisive, but I would suggest that that is a flaw both in the district court's reasoning and in Grutter in general, in that it encourages and it basically nullifies strict scrutiny in some ways when you have this many-factor analysis that makes it more difficult to see what effect the racial classification
Can I
has
just
had.
ask you about that effect? Because I think we really have to drill down on that from a threshold jurisdictional standpoint. I think we have to understand whether race is being used in this context to give rise to an actual concrete particularized injury that would give the members of your organization standing to challenge the use of race in this context. And so I've been struggling to understand exactly, this is sort of where Justice Sotomayor was coming from. I've been struggling to understand how race is actually factoring into the admissions process here and whether there's any actual redressable injury that arises. So can you help us with that, figuring out how exactly does UNC's system work in terms of the use of race, and how your members are being harmed by that?
So let me start with the legal question, which is concrete injury. Gratz establishes that the denial of an opportunity to fairly compete for admission when one of the factors that's used is racial classifications is sufficient to create concrete injury.
Except
There's no
Gratz was like a set-aside. It was a specific set of circumstances. You could see there that the race factor was creating an unequal playing field because of the way in which the program was structured. Here, I don't really see that happening because no one is, first of all, the university is not requiring anybody to give their race at the beginning. When you give your race, you're not getting any special points. It's being treated just on par with other factors in the system. No one's automatically getting in because race is being used. There's no real work that it's doing separate and apart from the other factors in any different way, like it was in Gratz. And when you look at that case, it says specifically when there's a set-aside kind of program, then we have actual injury that gives rise to standing. But I'm not sure you have that here. So
Well,
can you help me?
Sorry.
Yes,
Yeah.
please.
Even Grutter establishes that a holistic admissions process doesn't make the injury go away.
But you've said Grutter needs to be overruled, so we can't, I don't think we can use that decision as the basis for
No, one
standing.
of the problems with Grutter that I think illustrates this specifically is Grutter's suggestion that race can only be used as a plus factor and never a minus factor, but as many of the dissenting opinions in that case observed, and cases from, or opinions from this court have since observed, that makes no sense in a zero-sum game. If we are going to consider race, and we argue that a racial classification, which is highly disfavored at law because of its necessarily invidious nature, is going to be used,
But
then
wait,
presumably it must be doing some work.
I actually don't think that that's the way standing ordinarily works, and I'm worried that you're asking us for a special standing rule.
Well,
that you're saying that we can challenge the use of race as a factor without explaining how it's factoring in and how that harms our members.
Well,
so why is it that race is doing anything different to your members' ability to compete in this environment? They can still get extra points. The points are not being tallied. There's no goal. There's no target. But in any event, they can get points for diversity even in this environment. So why does having race as a factor harm your members in a redressable way?
The record in this case is that UNC gives racial preferences to African Americans, to Hispanic Americans, and to American Indians. It does not give racial preferences to white applicants and to Asian applicants. Moreover,
Are you sure about that? Because
yeah.
I thought that was not a rule, that anyone could get a point for diversity, anyone could get a point for racial diversity to the extent that the other factors in their application allow for it.
No, the UNC, and I think this is in the district court's findings, specifically gives its racial preferences for what it defines as URMs, which are the three groups that I said. And moreover, any effect of race in the process is going to give rise to injury, because the injury that Gratz recognized and that Grutter did not hesitate in at least finding standing in that case and moving on to the merits decision, is that you are being denied the opportunity to compete on a fair playing field, at least a constitutional playing field.
Mr. Starbridge, can I take you back to Justice Sotomayor's question? She described an applicant who came from an underprivileged school, who maybe didn't have the best teaching, best opportunities to score well on the SAT. And I want to know whether, in your view of the world, if a student wrote an essay describing some of the experiences that Justice Sotomayor said, I struggled with socioeconomic diversity, racial prejudice, things that shape who I am. In your view of the world, could a university take that into account without offending the Equal Protection Clause?
Yes, I think this court's precedents even note that the act of overcoming discrimination is a separate and apart distinction from race, in part because any member of a race may be in a position, or a member of any race might be put in a position where they feel somewhat isolated or somewhat different.
Okay, so I understood you telling Justice Sotomayor that you thought that would not be permissible, but that's not your...
No, I think I meant to say quite different. What we object to is a consideration of race and race by
race
itself.
in a box-checking way as opposed to race in an experiential statement.
Which the record in this case is that they can give the preference based on the check of the box alone.
Thank you.
Where?
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 Well, they use a whole...
Show me one place the district court found that an applicant checking a box automatically gets a greater point system.
Well, I did not say it automatically gets the point. They said that they can take race into account based on that information alone. The testimony is not necessary.
But you're making assumptions with that, because I can look at something and say, okay, now let me read the rest of the application and see if that warrants that extra point. But where, can you point into the record where merely checking the box, standing alone as one factor, got somebody in?
Well, of course, there's an email exchange in the record, some of which is sealed, but I think that the court's familiar with its
That
contents.
was one person and not the entire committee.
I think it was a chat between 3 people.
Well,
Did
who
that
were all
person get
admissions
a
member
point as a
committee.
result?
or is that the Harvard case? I'm sorry. It might be the Harvard.
May I go back to Justice Barrett's question and just make sure I understand your answer to it? You said not race in a box-checking way, but then Justice Barrett said race in an experiential way, and you said yes to that. And you said, well, of course, you can always say that you've been subject to discrimination. And certainly being subject to discrimination is one part of what it means to have race affect your experiences generally. I mean, what are you saying a college can look at, and what are you saying a college can't look at when they're reading an essay about, the experiences that a person has had in their lives?
Well, the reason why race may have some contextual relevance when you're evaluating an essay, right? A story about being subjected to racial discrimination obviously indicates that the applicant has grit, that the applicant has overcome some hardship. It tells you something about the character and the experience of the applicant other than their skin color. So that's what we object to.
So you said, again, being subject to discrimination. Are you conceding, too, that there are other aspects of racial identity that could form part of an essay that universities would want to look at? Or are you saying, no, this just has to be if you have complaints about racial discrimination?
Well, no. For example, a student, an Asian American student who took an active interest in perhaps, traveling back to their grandmother's, country of origin, or somebody who, was involved in some extracurricular activities with a particular, interest in supporting, Asian American students, for example. Those kind of show dedication. They show extracurricular involvement. They show perhaps a global interest in the world. There's all sorts of non-racial criteria those meet.
They also show a pretty not very savvy applicant, right? Because the one thing his essay is going to show is that he's Asian American, and those are the people who are discriminated against.
Yes, that is true, and that's the record in both cases, is that racial preferences operate to the disadvantage of Asian American applicants.
So it is the case that African American applicants can highlight that aspect of their background and situations such as the one that you mentioned, and that people reading that file in the admissions office can look at that and take that into account.
Yes, what we object them taking into account is just race, independent of any of that kind of information.
But how are they taking into account race independent of the rest of the information in a holistic review process? So my other question was about this same thing, which is, how is race being used in this process? You keep saying we object to the use of race standing alone. But as I read the record and understand their process, it's never standing alone, that it's in the context of all of the other factors. There are 40 factors about all sorts of things that the admissions office is looking at, and you haven't demonstrated or shown one situation in which all they look at is race and take from that stereotypes and other things. They're looking at the full person with all of these characteristics.
Yes, but our point is that all those other characteristics are not barred by the Constitution, and the use of race as a classification is barred by the Constitution.
But it has to be used, doesn't it? I mean, just because somebody checks a box, what if they check the box and the university sees that, but doesn't look at it, doesn't take it into account in any way in the application? Do we have a constitutional violation just because the student voluntarily said, I'm an African American, but that never comes into play?
If the university admissions process instructs readers not to take that into account or to not award any benefit toward admission on that basis, then that is not necessarily a problem.
No instruction. It just never actually comes into play. Because if you say that, what I think you're saying is that people have to mask their identities when they come into contact with the admissions office just on the basis of their difference.
Well,
it never comes into play.
I don't think this is a lot different than a couple of other criteria. For example, the UNC's official position at trial was that gender is not a basis for admission, that admissions officers are not supposed to take gender into account. That doesn't mean that they're not aware that there are women applying, but the instructions are not to take gender into account, and to my knowledge, we don't see a large effect at all suggesting that that gender is playing a role. But both experts in this case found that race was in fact mattering to a number of applications. You can debate between our expert and their expert whether it's only 500 or it's 1,700 or it's 2,000 applications a year, but it is having an effect. If it's not having an effect, they've spent an awful lot of time and money opposing the relief we're seeking in this case.
Mr. Strawbridge, let me give you a hypothetical along the lines of some of what you've been questioned about already. Suppose that a student is an immigrant from Africa and moves to a rural area in western North Carolina where the population is overwhelmingly white. And the student in an essay doesn't say this, I was subjected to any kind of overt discrimination, but I did have to deal with huge cultural differences. I had to find a way of relating to my classmates who came from very different backgrounds. Would that be permissible?
I think that would generally be permissible because the preference in that case is not being based upon the race, but upon the cultural experiences or the ability to adapt or the fact to encounter a new language in a new environment.
The race is part of the culture, and the culture is part of the race, isn't it? I mean, that's slicing the bologna awfully thin.
Well, we could say the same in the jury selection cases. We could say the same in the child custody cases. There's still a difference between using an express racial classification. When you use race, you are telling applicants that their race matters, that it means something that is inherently divisive. It gets us further away from a world where the government treats race as irrelevant.
But they're offering it because they're saying that race matters to me. I mean, this is not a situation in which the university is asking or telling every applicant, give us your race so that we can classify people, so that we can give certain people preferences. The only reason why the university knows the race of any of these applicants is because they are voluntarily providing that.
But it is making distinctions upon who it will admit, at least in part, on the race of the applicant. Some races get a benefit, some races do not get a benefit.
Counsel, I'm sorry, go ahead. Our precedents, just turning to our precedents for a moment, distinguish on the one hand between racial quotas, which Justice Powell and Bakke said would be impermissible, with pursuing racial diversity and critical mass of different races on campus, in Grutter, for example. How are we to think about distinguishing between those concepts?
Well, so the racial diversity point is interesting because the court's other precedents have rejected racial diversity as a compelling interest in the employment context, in Wygant at least. It's rejected racial diversity as a relevant factor in K through 12 education. So we think that Grutter is an exception to that, and those other cases are better reasoned in this point in terms of disfavoring the use of race by the government.
So in your view, and I take this to be the purport of most of your briefs, not putting aside the last 10 pages or so, but in your view, it really wouldn't matter if there was a precipitous decline in minority admissions, African American, Hispanic, one or the other. If I think there are some numbers in this case, but suppose that it just fell through the floor. Would it just, too bad?
Well, I don't think that it's going to fall through the floor if the university is actually committed to the broader diversity it wants. Because
right, I know you think that, and there's been obviously a lot of the litigation has been about that. How much will it decline, and your expert and their expert. But the logic of your position suggests that that really doesn't matter. I mean, the last 10 pages of your brief where you say, has there been narrow tailoring here, it matters in that 10 pages. But it doesn't matter if you're saying there's a categorical rule, no race shall be involved in admissions decisions, then it doesn't matter if minority enrollment or particular kinds of minority enrollment fall through the floor, does it?
If the application process is open and that is a result of the criteria that the university has elected to choose and it's not discriminatory under this court's other precedents, then that is the educational decision the university has made. I doubt any university would ever make that decision. That has not been the experience, for example, in Florida, which is race neutral, has very similar demographics to UNC, and by UNC's own admission in this record, actually achieves better racial diversity as well as 50% greater number of programs
right, well, that
on
gets
campus.
us back to this question of what universities can do with what purpose to achieve racial diversity even without being explicit about racial classifications. But putting that aside, I mean, I guess what I'm saying is your brief, and this is very explicit in your brief, is like it just doesn't matter if our institutions look like America. You say this on page 11 in your reply brief. And I guess what I'm asking you is, doesn't it? I mean, doesn't it? These are the pipelines to leadership in our society. It might be military leadership. It might be business leadership. It might be leadership in the law. It might be leadership in all kinds of different areas. Universities are the pipeline to that leadership. Now, if universities are not racially diverse and your rule suggests that it doesn't matter, well, then all of those institutions are not going to be racially diverse either. And I thought that part of what it meant to be an American and to believe in American pluralism is that actually our institutions, you know, are reflective of who we are as a people in all our variety.
I think that's right. I think the reason that we think that and why that is a great American ideal is because we expect that the government is going to be open to everybody who wishes to apply, and that because merit and your worth as a person and your value as a contributory citizen is not correlated with your skin color. And so naturally, a government that treats people fairly and that makes opportunity open to all will necessarily see racial diversity.
But Mr.
And indeed, that's been the
you
experience
said,
before.
and I think you're right to say this, you said to one of my colleagues' questions, you know, if this didn't matter, they're spending an awful lot of time and money and anxiety doing something that doesn't matter. So let's presume it does matter. Let's presume it does matter that these programs have been understood to be necessary to ensure that these institutions have a certain level of racial diversity. And I concede what Justice Gorsuch says, that racial diversity and quotas, it's a little bit mysterious, but have a certain level of racial diversity that will enable them to get the benefits of all our many different peoples, and that enables American society generally to do the same.
Well, because I think one of the problems with Grutter is that it suggests that this is somehow costless, that if it's one factor among many and we can't identify, you know, exactly how many points race is getting, although obviously statistical analysis does allow us to do that at some point, Grutter says it's not that big of a deal, it's always a plus factor and never a negative, but this is a zero-sum game. That is one of the problems with Grutter, is it suggests that the harm of racial classifications, which this court have always recognized are inherent and invidious of themselves, can be you know, hidden or pushed down as long as race is just one of many factors.
Counsel, if you have, I thought your objection is also that the race-neutral alternatives, you have to try race-neutral alternatives first. You don't think the university has, right?
We do not think that the university has made a commitment to race-neutral alternatives, and we presented a lot of evidence on this case, and we do not think the district court's analysis is consistent with strict scrutiny, even as Grutter requires it. And
so if they do, if they cannot take the box being checked into account or can't do that, and do try race-neutral alternatives, is there any evidence in the record about what the results of those would be? In other words, to take an example, if all of a sudden the number of essays that talk about the experience of being an African American in society rises dramatically, will the consequences of that be the same as if they're not being mentioned, but instead race is taken into account automatically?
I want to make sure I understand Your Honor's question.
Might have been a little awkwardly phrased.
I would never suggest that. Is the question as to whether or not there's some sort of cheating going on, or is the question whether the race-neutral?
Not a bit. The question is, the discussion has been about the dramatic plummeting of the number of African-American students that would take place if the practice of checking the box with race is taken away. And my suggestion is, if that's not, then maybe there will be an incentive for the university to, in fact, truly pursue race-neutral alternatives, such as, allowing, which I think would be allowed, students, applicants, to indicate experiences they have had because of their race.
I think that's correct. And just so we're clear, there's a lot of room for UNC in particular to improve its socioeconomic diversity commitment. It claims to value this, but the preference, at least according to our experts' testimony, that it gives for socioeconomic status is lesser than it gives to race. Something like the average median income in North Carolina is about $53,000 a year, but the average UNC student comes from a family making $153,000 a year. And at least at trial, there was testimony from the director of admissions that the percentage of first-generation college students and the students who were receiving scholarships under the Carolina Covenant, which is a socioeconomic benefit, had declined in recent years.
Your position will put a lot of pressure going forward, if it's accepted, on what qualifies as race neutral in the first place. You said socioeconomic is race neutral, top 10% plan, race neutral. You want to respond to that?
Well, I'm sorry. I did not mean to interrupt. I just wanted to say that I actually don't think that's been the experience. There are 9 states that have barred the use of race in their college admissions program. We're not aware of anyone who has challenged a race-neutral alternative on the ground that it somehow...
Right. I'm just making sure what qualifies as race-neutral in the first place. What if the college says we're going to give a plus to descendants of slaves? Is that race-neutral or not?
I think descendants of slaves is a very difficult question because it's so highly correlated with race in the history of our country. I'm not sure that any college has proposed that kind of a preference. It would
Well, I know we have to think forward about what will happen if you prevail in this case, and that seems a potential, so I'm curious about your answer to that question.
My instinct standing here is if that were the only basis, then that very quickly starts to look like just a pure proxy for race. It would obviously depend on the actual program as it was implemented.
Could you give a plus to applicants whose parents were immigrants to this country?
I think that
Is that race neutral?
I think that if it is immigrants regardless of country and regardless of their racial descendant, I think that is probably closer to being okay.
Counsel, what did the evidence show in terms of race-neutral alternatives from your perspective?
The race-neutral...
Would numbers plummet?
No, following the analysis that was used in the other case, we presented a number of circumstances, some of which assumed a holistic process, just a holistic process that was no longer putting a thumb on the scale for students of particular races. And it showed that you could get to the current academic credentials of UNC, average SAT and GPA within 15 points. You could get very similar, less than a 1% difference in the individual racial breakdowns to the extent those are relevant, so, equal or greater than overall underrepresented minority representation. And of course, socioeconomic diversity would increase significantly. I think it is telling in the district court's analysis that it gave absolutely little weight to the possibility of a socioeconomic preference. It suggested that would create a kind of diversity that's different than what UNC prefers, and of course we think that's part of the problem.
I looked at all of your simulations, every one of them. So did the district court. And in every one of them, white representation stayed the same or went up. And some minority groups increased, but others did not. Blacks decreased in every one of your simulations. The district court also looked at your simulations and found that each and every one of them had fatal statistical flaws, not the least of which that you relied on unrealistic assumptions about the applicant pool. In one of them, the modified Hoxie simulation, which you seem to be relying on here, assumes UNC could admit the state's 750 highest scoring, most socioeconomically disadvantaged public high school students. That all of them would apply, that all of them would accept, is as unrealistic as you can get. So there isn't one stimulation that you put forth that achieved the numbers that are being achieved today. They're imperfect. We have no racial quotas. We don't have proportionate representation. But show me a simulation in any of your 2 cases that reach the numbers for every ethnic group involved.
Well, of course, that suggests that the standard is a particular percentage of representation in the student body, which even Grutter purports to disclaim.
No, I'm just saying we know that representation for Asian Americans, for example, has grown dramatically over time. As their numbers in the population have increased, so have their admissions numbers. But I'm just saying, if we don't have proportionality, and no one's seeking that because that would be a racial classification. If we have improvement, all I see in your models is that we step backwards, we don't step forward.
I think I disagree with that for a couple of reasons. First of all,
Well, the district court
Why don't
did.
you tell us what the reasons are?
Well, first of all, the district court basically conflated the educational benefits of diversity, which is actually the interest that Greta recognizes, with raw representation on campus. And I don't think those two things can be tied, and I don't think there's any evidence in the record by UNC, which is supposed to bear the burden of proof under strict scrutiny, that having a black population on campus of 8.6% versus 8.4% results in fewer benefits of educational.
Thank you, counsel. You'll be able to return to Justice Sotomayor in just a moment. Justice Thomas, anything further? Justice Alito? Justice Sotomayor?
Yes, just to finish that point, we
Yes.
do know that when numbers decreased in schools like the University of California, University of Michigan, in the upper tier schools in the Oklahoma system, that blacks have reported feeling isolated and having their voices stifled there.
Yes, although the correlation that's offered in some of the amicus briefs breaks down if you actually look at the underlying information. Just to take California, for example, at UC Davis, which has African American representation, several points lower than at UC Merced, there's less reports of isolation. And you can see that even at the UNC campus. There are some students, even under their policies today, who report feelings of racial isolation. But Native Americans, who of course have a small percentage of representation on campus compared to African Americans, report feeling less racially isolated. So I think the suggestion that that can be the standard by which we judge a race-neutral alternative is insufficient.
Justice Kagan?
This is a little bit off the track here, but you made a reference earlier in your remarks about gender differences. And there's a lot of statistical evidence that suggests that colleges now, when they apply gender-neutral criteria, get many more women than men, and assume that that continues to be true, so that using gender-neutral criteria, men are 30% of a class or 35%. And a university said, that's neither healthy for our university life, nor is it healthy for society that men are so undereducated as compared to women. Could a university put a thumb on the scales and say, it's important that we ensure that men continue to receive college educations at not perfect equality but like roughly in the same ballpark?
Well, of course, under this court's precedent with respect to the Equal Protection Clause, that is subject to a somewhat lesser level of scrutiny than racial classifications are. So even if they could justify them under this court's equal protection jurisprudence, I don't think it follows that they can justify racial classifications.
Yeah, I mean, you're right about the levels of scrutiny, but that would be peculiar, wouldn't it? Like white men get the thumb on the scale, but people who have been kicked in the teeth by our society for centuries do not?
Well, of course, our position is that white men could not get a thumb on the scale. That sounds like a racial classification. Men could, perhaps, but not white men. Yeah, but the answer is, could you survive intermediate scrutiny in that case? I don't know, but we have never said that gender differences, at least the court has never suggested that sex discrimination under the Equal Protection Clause rises to the inherent invidious level that racial classifications do. In this case, it's about racial classifications.
Justice Gorsuch?
Well, this court in the Virginia Military Institute case said that gender would be an impermissible basis for discriminating against applicants there.
Yes, and obviously the situation was somewhat different in that it was a total exclusion, if I recall correctly, in that case. But I do not want to concede that there would ever be an appropriate place to have a sex-based characteristic. I'm just noting it's different under the precedent than race.
And how about religion, for example? There's some evidence, for example, that Harvard adopted its holistic admissions approach in part because it was concerned by the burgeoning number of Jewish persons who were attending, and they were looking for a way to reduce the number of Jewish persons without resorting to a quota. At least that's what some of the amici tell us.
Yes, I mean, that is the history, and I think it's an illustration why putting something in a holistic admissions process doesn't prevent the very invidious effects that this court has always recognized with racial characteristics.
Then I want to ask you about Title VI in isolation. Put aside our precedent for the moment. Title VI says that no person shall be excluded from participation or be subjected to discrimination under any program or activity that receives federal financial assistance. In Bakke, Justice Stevens argued that whatever the 14th Amendment may allow, Title VI does not permit the use of race. You didn't make much of that point in your briefs, and I just wanted to understand why.
I don't think it's necessary to make that much point in the brief, because in our view, at least within the educational context, there's really not a difference between how the 14th Amendment should read and Title VI's prohibition should read. We understand that some people view the Title VI language as even more clear. We would obviously win under that view, but it hasn't been briefed, and I don't think it can be justified as a route to decision here as some sort of constitutional avoidance, because the constitutional question has been decided in Grutter. We submitted has been decided incorrectly, and so you wouldn't be avoiding a constitutional decision. You'd just be leaving, in our view, a bad decision on the books.
Thank you.
Justice Kavanaugh?
You're asking us to overrule Grutter, but first want to understand what you think Grutter itself means. It had language in there about a 25-year limit. The decision was in 2003. The current admission cycle is for the class of 27. It's going to be too late to do anything about that cycle. The next is the class of 28. When do you read, or do you calculate, to the extent you consider it at all, the 25-year limit? And more broadly, just how should we think about that sentence, which was part of 4 important paragraphs in Grutter about the importance of race-conscious decision-making being time-limited and temporary?
So we do not understand the 25-year limit somehow to have been a hard and fast requirement. Certainly, different justices of the court in Grutter took differing positions as to whether it should be.
So do you think it could go for 35 or 50 years then?
Well, I think that the language in Grutter at least had an aspirational element to it, but it was aspirational for a reason. And Grutter definitely, in those paragraphs that precede that clause, make very clear that they want the use of race to be diminishing over time, and they want colleges to be seriously looking at how to get away from race. The record in this case indicates that that's not actually happening. Indeed, the head of UNC's Race Neutral Alternatives Committee testified that if the racial distribution on campus was 20% African American, 20% Asian American, 20% Hispanic, and 20% Native American, that was still not sufficient to convince her that they would stop using race. The chancellor of the university said if UNC had the highest level of minority representation in the country, that would not be sufficient to convince them that they should stop using race.
Second question, again, a little off track here, but we're thinking about what would happen if you prevail in this case. There's an amicus brief from Catholic universities that say private religious colleges would have a RFRA or free exercise right to continue to engage in affirmative action because it's part of their religious mission. Do you have any views on that?
I don't know that I have any specific views on that brief. I mean, there is sometimes, at least historically, there has been sometimes a conflation of race and religion. I think that some people would have thought that Harvard's policy back in the 1920s was a racial policy as opposed to a religious policy. There may be difficult questions there, but I think that in this case, there's no suggestion that RFRA has any role to play, and we think the Equal Protection Clause dominates.
Thank you.
Justice Barrett?
Mr. Strawbridge, do you agree that universities have a compelling interest in the educational benefits of diversity writ large, not just racial diversity, but having, difference of genders, different religions, different viewpoints in the classroom because of the educational benefit of bringing different perspectives to bear in a question?
I don't think the compelling interest question can be answered apart from what the policy that's being considered is. In this case, we don't think it's an interest that is compelling enough to justify a racial
I understand that, but do you agree, let's take the compelling away from it. Do you agree that they have an interest in?
Sure. I have no doubt, and I agree that universities have an interest in the broadly defined, in achieving the kind of broadly defined diversity that is talked about sometimes in Grutter and sometimes in the brief.
And how would you suggest that they go about achieving that? Like, let's say that you prevail, but universities still have this interest in assembling diverse classes, full of students that bring different experiences and perspectives to bear, and they decide not to adopt a 10% plan. So I assume it's all done then in holistic review.
Yes, and there's nothing wrong with, holistic review takes place today at colleges that do not use race as a factor in admissions, and there's no reason to assume, and there's no evidence in the record that the students at those colleges are not receiving the educational benefits of diversity.
I guess what I'm concerned about is if it puts a lot of pressure on the essay writing in the holistic review process, you can have viewpoint discrimination issues, I would think, depending on how admissions officers treat essays. You could have free exercise claims not by religiously affiliated universities who want to give bumps to, say, LDS students, but, if you have Harvard, say, saying, well, we want this many Jews, but we also want this many Christians, and this many Muslims in a classroom.
Well, I guess we don't even understand Grutter in parts to be suggesting that the interest in this broad benefit of diversity actually justifies kind of micromanaging the populations on campus in the way that you're suggesting. And I don't think that the universities are doing that with respect to socioeconomic diversity, at least if UNC has a cap on the number of socioeconomically challenged students that they're willing to admit. They haven't said that. So I'm not sure that it follows that, in a scenario where we prevail, that it's going to affect one way or another the holistic admissions process. Florida is holistic. I believe the California system is holistic. I think Michigan is still holistic.
Thanks.
Justice Jackson?
Yeah, so two questions. Is there any indication from this record that UNC is doing the kind of micromanaging you're talking about with respect to racial classifications? I didn't see that they were shooting for a particular target or that there was a goal, or that I thought, in fact, that as the reviewers went through the process, they didn't even know how many other students of color had been admitted, and if they did know, they had to be recused. So they're not operating the system, I thought, to reach toward some sort of racial goal. Am I wrong about that?
Well, that policy was instituted after our lawsuit was filed. Before our lawsuit was filed, at least senior admissions officers who were reading files were allowed to see those.
So the policy is that they're not reaching towards some sort of goal.
As a post-litigation, no, I would not go so far as to say that. And in particular, I would look at the race-neutral alternatives analysis that UNC's own expert proffered, and this is actually throughout the record, even in the admissions
All right,
offices.
I have little time. I'm sorry.
No, I'm sorry. I don't.
Yeah, but you say they've changed the process, but now at least they're not looking toward a goal they're not race balancing in that same sense.
No, I think they measured their standard as to what they could achieve by race-neutral alternatives, by whether they can replicate the precise level of diversity to today. So I think that is a form of.
All right, so let me ask you another question, because I take it that your position is that UNC is allowed to consider other non-race-based personal characteristics of individual applicants, like someone's status as a parent or a military veteran or a disabled person, and give pluses in the current holistic environment for those characteristics without running afoul of the 14th Amendment. Is that right?
I think that is generally correct, as long as it's a criteria that is not walled off by the 14th Amendment. It's appropriate.
They can give pluses. And so what I'm worried about is that the rule that you're advocating, that in the context of a holistic review process, a university can take into account and value all of the other background and personal characteristics of other applicants, but they can't value race. What I'm worried about is that that seems to me to have the potential of causing more of an equal protection problem than it's actually solving. And the reason why I get to that possible conclusion is thinking about two applicants who would like to have their family backgrounds credited in this applications process, and I'm hoping to get your reaction to this hypothetical. The first applicant says, I'm from North Carolina. My family has been in this area for generations, since before the Civil War, and I would like you to know that I will be the 5th generation to graduate from the University of North Carolina. I now have that opportunity to do that, and given my family background, it's important to me that I get to attend this university. I want to honor my family's legacy by going to this school. The second applicant says, I'm from North Carolina. My family's been in this area for generations, since before the Civil War, but they were slaves and never had a chance to attend this venerable institution. As an African American, I now have that opportunity, and given my family background, it's important to me to attend this university. I want to honor my family legacy by going to this school. Now, as I understand your no race-conscious admissions rule, these two applicants would have a dramatically different opportunity to tell their family stories and to have them count. The first applicant would be able to have his family background considered and valued by the institution as a part of its consideration of whether or not to admit him, while the second one wouldn't be able to, because his story is in many ways bound up with his race and with the race of his ancestors. So I want to know, based on how your rule would likely play out in scenarios like that, why excluding consideration of race in a situation in which the person is not saying that his race is something that has impacted him in a negative way. He just wants to have it honored, just like the other person has their personal background, family story honored. Why is telling him no not an equal protection violation?
Well, I think because if it is the racial aspect of the application, then that's the equal protection requires that people of all races be treated equally. Now, certainly UNC shouldn't give a legacy benefit if they don't want to give a legacy benefit. There's no obligation they do that. And
no,
of course,
but I'm sorry, but you said it was okay if they give him a legacy benefit. And what I'm saying is that in almost exactly the same set of circumstances, a student or an applicant who is African American and who would like to have the fact that he's been in North Carolina for generations through his family and that they've never had a chance to go to this school honored and considered, and it's bound up with his race. You say, I think, that he's not allowed to say that and that the university is not allowed to take that into account. And because it relates to race, precisely because it relates to race, I think you might have an equal protection problem in saying that he can't get credit for that when someone else can.
Well, for purpose of the hypothetical, I am assuming that the only significant factor in that story happens to be the fact that of the race of the applicant and that their race was previously barred from attending UNC. Obviously, nothing stops UNC from honoring those who have overcome slavery or recognizing its past contribution to racial segregation. But the question is that a basis to make decisions about admission of students who were born in 2003? And I don't think that it necessarily is. I don't think that the Equal Protection Clause suggests that it is. There are many factors in an application like that might be appropriate to consider, including if they are first-generation college or including if they are socioeconomically depressed. But if the only difference is between a white student and a black student, I don't think the Equal Protection Clause permits the admissions decision to hinge on that.
Thank you, counsel. Mr. Park?
Mr. Chief Justice, and may it please the court. Diversity is our nation's greatest source of strength. But as our Reconstruction founders understood and our nation's history confirms, it also poses unique challenges to the American experiment. We live in a large and sometimes unwieldy democracy, and for that democracy to flourish, people of all different backgrounds and perspectives have to learn to live together and unite in common purpose. It was Brown's vision that education could be the engine of our democracy, a place where students could prepare for the rights and obligations of citizenship in a diverse and inclusive setting. The University of North Carolina at Chapel Hill seeks to fulfill Brown's vision by assembling a student body that is diverse along the many dimensions that matter in American life, including race, but also social class, geography, military status, intellectual views, and much more. This learning environment helps us seek truth, build bridges across students of different backgrounds, and critically here, equip students with the tools needed to function effectively as citizens and leaders in our complex and increasingly diverse society. The university pursues these interests in scrupulous compliance with this court's precedents, which have consistently held for decades that seeking the educational benefits of diversity is a compelling interest of the highest order, and that universities may consider all aspects of an applicant's background to build a thriving campus community. The correctness of these precedents is confirmed by the historical record, which shows beyond doubt that our Reconstruction founders believed that race-conscious measures designed to promote an integrated learning environment were consistent with the original public meaning of the Equal Protection Clause. To be clear, UNC would like nothing more than to achieve its educational aims through race-neutral means. It has taken extensive efforts to do so and has seen steady and continuing progress toward this goal. But this progress has been halting. and the university retains a powerful interest in preventing the backsliding that would occur if this court took away the power to decide this important social policy issue from the people of North Carolina. I welcome the court's questions.
Mr. Park, I've heard the word diversity quite a few times, and I don't have a clue what it means. It seems to mean everything for everyone. And I'd like you first, you did give some examples in your opening remarks, but I'd like you to give us a specific definition of diversity in the context of the University of North Carolina. And I'd also like you to give us a clear idea of exactly what the educational benefits of diversity at the University of North Carolina would be.
Yes, Your Honor. So first, we define diversity the way this court has in its court's precedents, which means a broadly diverse set of criteria that extends to all different backgrounds and perspectives and not solely limited to race. And there's a factual finding in this record, PEDAP 113, that there are many different diversity factors that are considered as a greater factor in our admissions process than race. We have a particular interest in recruiting and enrolling rural North Carolinians. In the last incoming class, 4 out of every 10 students who entered the campus doors were from rural North Carolina. 1 out of every 12 students has a military affiliation, including the most veterans on campus since World War II. And so we value diversity of all different kinds and all the ways that people differ in our society. On the educational benefits question, Your Honor, I don't think it's actually disputed here that there are real and meaningful educational benefits that come with diversity of all kinds. SFFA's own expert, this is on JA 546, conceded and agreed enthusiastically, in fact, on the stand, that a racially diverse and a diversity of all kinds leads to, quote, a deeper and richer learning environment, leads to more creative thinking and exchange of ideas, and critically reduced bias between people of different backgrounds and not solely different racial backgrounds.
But you still haven't given me the educational benefits. I didn't go to racially diverse schools, but there were educational benefits. And I'd like you to tell me expressly, when a parent sends a kid to college, that they don't necessarily send them there to have fun or feel good or anything like that. They send them there to learn physics or chemistry or whatever they're studying. So tell me what the educational benefits are.
So there's 3 main buckets, Your Honor, and the first, and I think most pertinent to the question that you asked, is the actual truth-seeking function of learning in a diverse environment. I would direct the court to the Major American Businesses brief, which discusses a whole extensive, rigorous, peer-reviewed literature that diverse groups of people actually perform at a higher level. So the most concrete possible scenario is stock trading. And there are studies that find that racially diverse groups of people making trading decisions perform at a higher level, make more efficient trading decisions. And the mechanism there is that it reduces groupthink and people have longer and more sustained disagreement, and that leads to a more efficient outcome.
Well, I guess I don't put much stock in that because I've heard similar arguments in favor of segregation too. I'd like to go to something different, to deference. In the area of a compelling interest. This court in Grutter did not specifically put the test to Michigan as far as diversity being a compelling interest. I'd like you to explain why in this area of strict scrutiny we have a lower standards. We defer to the accused discriminator. But in the instance of sex discrimination at VMI, the accused discriminator was put to the test, and the court did not defer to VMI, but it deferred to Michigan. Why that difference? And why should you not be treated the way we would treat someone in a Title VII case or a Title VI case and shift the burden to the discriminator to explain the conduct?
Our understanding of the deference that this court provides and the deference that we request is quite limited, Your Honor. We ask for deference in terms of our educational objectives and not the legal question of whether those objectives constitute a compelling interest. And I think that it's pretty clear to see why. I think that is similar to the VMI context. So like I mentioned, we have made it a system-wide priority to...
The court did not defer in VMI.
So I think it did to the extent that it held that the interest in a rigorous military education is an interest that the institution had. And so if UNC decided at a system-wide level to say we're going to completely change our educational mission and make it into an institution like VMI, I think the compelling interest analysis would proceed with that educational objective in mind. But we do not take the position that the compelling interest standard is somehow subject to deference. That's a legal question.
Just to follow up on Justice Thomas's questions about diversity, again, these holistic admissions approaches seem to stem from the 1920s at Harvard, and they were used as cover for quotas for Jewish persons who the university apparently felt had too many students attending. And I guess I'm struggling still to understand how you distinguish between what this court has said is impermissible, a quota, with what you argue should be permissible going forward, which is diversity. How can you do diversity without taking account of numbers?
So I think there's two separate points I'd like to make on that, Your Honor. So on the sordid history of the early holistic process, I don't think anyone has ever accused the University of North Carolina as having...
I'm not suggesting that.
Yeah, and we took our cues from this court, from the Bakke decision, and from...
I understand that too. But I guess my question again, just to get to the core of it rather than circling around it, is how can you do diversity, which that's what you're arguing for, without taking account of numbers?
Our interest in what we believe that Grutter requires of us is individualized, holistic review. And I think there's actually been a lot of misconception.
But if you don't achieve, you have to achieve diversity, though. That's the goal. So how do you do that? Again, last time I'll ask it without looking at numbers.
We do so by looking at the individual applicant. We do not have some sort of racial target or a target for other diversity metrics. For example, we don't say we want to have 10% of our class be military veterans. We say we value this diversity interest, and we're going to look at each individual applicant on that basis.
What is your goal, and how will a court ever be able to determine whether your goal has been reached?
Our goal is to achieve the educational benefits of diversity. And I understand that that is a qualitative standard that is difficult to measure, but I do not believe that a standard merely being qualitative means that it is not susceptible to rigorous review. And if I could give an example, so we are subject to a statutory mandate that we create an open and tolerant speech environment for all sorts of views, even views that many find disagreeable. And we engage in the same kind of analysis to measure whether we are meeting this standard. It's principally survey-based as well as examination of objective.
Your brief repeatedly refers to certain students as members of underrepresented minorities, right? What does that mean? Why is that significant?
So I think this is helpful because this pierces the main, I think, misunderstanding about how our process works. We do define certain groups based on their overall representation in the state of North Carolina. That stems from a consent decree that the University of North Carolina entered with the Reagan administration.
Well, I mean, this is really pretty simple. Suppose you assembled a student body in which the various racial groups coincide almost exactly to the percentage of those racial groups in the general population. Would you say, okay, now we've done it, we've achieved diversity?
No, Your Honor, and I don't think that we would say that we need to reach those levels either. I think the student interveners will stand up and say that we should be doing far more, but we are trying to comply with this court's precedents, which require the minimal consideration of race on a holistic basis.
This court's precedents, I mean, Grutter also says, sorry, let me put my readers on here, using racial classifications are so potentially dangerous, however compelling their goals, they can be employed no more broadly. Going down a little bit further, all governmental use of race must have a logical endpoint, reasonable durational limits, sunset provisions in race-conscious admissions policies, and I gather, Justice Alito is saying, when does it end? When is your sunset? When will you know? Because Grutter very clearly says this is so dangerous. Grutter doesn't say this is great, we embrace this. Grutter says this is dangerous and it has to have an endpoint. And I hear you telling Justice Alito there is no endpoint.
No, Your Honor, and I apologize if I gave that impression. So 3 points on the endpoint. We enthusiastically embrace the durational requirement, and we have tried to do everything possible to adopt race-neutral alternatives from the time of Grutter to today to minimize our consideration of race. In a university where our endowment during the record was around $3 billion, we have spent well north of $1 billion on financial aid programs to try to recruit low-income students across the board. And I think that that's the first generation race-neutral alternatives. And the second are to try to expand the pool. We have an incredibly extensive program where around half of our transfer students come from community colleges.
But if I could just interrupt for 1 second, how do you know when you're done? Justice Alito said if you have exact correlations to the the percentage in the population of a particular group, and you said you're not done then. So when would when would you have the endpoint?
I see.
I appreciate that you're undertaking all those efforts, but when is the endpoint?
I meant to respond to Justice Alito, meaning that we do not need to reach that point for us to feel that we have met our diversity goals. What we're doing today is we feel that we are achieving the educational benefits of diversity.
So it's not necessary, but is it sufficient?
I think that in that scenario, it might be likely that our qualitative process in terms of constant examination of our campus climate would reach a point where we would feel that we had reached the educational benefits of diversity.
But that's, I'm sorry, finish.
So I just want to be very clear on the endpoint, if I may. We think that the history shows that these programs can and do end. The early programs, as Justice Ginsburg has mentioned, many of them principally benefited white women. The program in Bakke and the federal contractor program this court upheld in Fully Love explicitly included Asian Americans as among their beneficiaries. And we have reached a point now where we feel that we are able to minimally consider race.
I don't see how you can say that the program will ever end. Your position is that race matters because it's necessary for diversity, which is necessary for the sort of education you want. It's not going to stop mattering at some particular point. You're always going to have to look at race because you say race matters to give us the necessary diversity.
So I think there's two different questions there. We don't think that the compelling interest in diversity will ever expire. I think the question is whether race-conscious measures need to be taken in the admissions process to reach our
You're going to have to
goals.
check, right? You're not going to know whether they have a sufficient number of African Americans to give you the diversity you say is necessary if you don't look and check.
I think there will be some attention to numbers, but the feedback loop between our assessment of our campus environment and the admissions process, we will celebrate the day when we get to the point where we have reached the point where we do now with our minimal consideration of race.
Well, I think the difficulty you're having answering some of these questions about endpoint were probably in the mind of Justice O'Connor when she wrote the opinion in Grutter for the majority, and as Justice Barrett said, indicated that these racial classifications are potentially dangerous and must have a logical endpoint. And instead of leaving it vague, the opinion didn't say until you reach a point where you're satisfied that diversity has been achieved or something vague like that. It said 25 years in there. And so I want to hear how you address that part of the Grutter precedent, because as I understand your answer, you would extend it far beyond 25 years indefinitely, and that would be an extension, I think, or you can tell me how you read the 25-year language. But I think the reason it's there, and I think it's real important because there are 4 paragraphs leading up to that, is because the difficulty you're having answering the question when, without that time limit, when it would otherwise be achieved.
So, of course, we don't read the 25-year as some sort of strict expiration, and I don't think on its face it was structured as such. Even Chief Justice Rehnquist in his dissent said this is not a fixed deadline.
Well, Justice Thomas, in his separate opinion, referred to it as a holding. Justice Kennedy referred to it as a pronouncement. So, anyway, just to make sure the full picture is presented there.
Yeah, so, Justice Kavanaugh, I think that every institution in every state will differ. I mean, we have states coming to the court and saying, we have reached our diversity, educational benefits of diversity goals. We don't need to engage in any race-conscious admissions process at our state flagships. And we are at the point where I think the expert evidence here pretty definitively shows that we are able to meet what we feel is an inclusive, diverse environment through minimal consideration of race. And I think that we will get there based on this qualitative process, but there is no strict numerical benchmark.
One of the things the other side has emphasized is that in the period since Grutter, in the 2 decades since Grutter, that we have more experience with states that don't allow race-based admissions, California, Florida, Washington, Michigan, and others, and that those examples now show with greater confidence than might have had in 2003, that some of the questions we were asking before, some of the race-neutral alternatives, can not have the risk of treating people differently on the basis of race on the file, but at the same time produce significant numbers of minority students on campuses. So in some ways, the experience, they say, is relevant. I'd be interested in your response of how to think about that.
Yes, I think that the experience of the University of Michigan system and University of California system helpfully illustrates the point I'm trying to make, which is they say that in their experience, it's really a campus-by-campus analysis, and in particular, the most selective public universities are continuing to have major struggles, particularly enrolling a sufficient number of African-American students for them to reach their educational goals. And I would direct the court to page 26 to 28 of the University of California's brief, because what they say they're experiencing is that there is actually an inverse relationship between African-American students and their sense of belonging and their sense of tokenism and isolation with how selective the university is. And so I think that's why you're seeing this wide spectrum of progress towards the day that we all are looking for, where we do no longer have to consider race.
Can I ask a question following up on Justice Thomas, too, about what diversity means? Does the University of North Carolina consider one's religion?
We consider it as part of our holistic process, yes. And so
Can you explain how that works?
Yes, and this is helpful because it's the exact same thing that we do for all of our other diversity goals, is if in context and an assessment of an individual applicant, their religious background or their religious experiences suggest that they might contribute something to our campus community, then that can be considered a positive attribute that is considered in our holistic process.
Do you have them check a box, though, as to what religion they are?
We do not have them check a box.
How do you know, then, what religion the majority of applicants are?
So our analysis on our religious tolerance climate is not pegged to the admissions process, but we do have an entire process set up and a whole range of programs to try to ensure an open and tolerant religious environment. And so we do engage in the same kinds of surveys and qualitative analysis of our campus community. And we're finding that on the whole, we feel we're meeting our goals, and we still have some struggles, particularly with Jewish and Muslim students feeling like they belong on campus.
Is the checking of the box with respect to race voluntary? Is it something that students are required to do, or something that they do on their own as a part of the process?
It is entirely voluntary, Your Honor.
So you don't know what the race is of all of the applicants who are coming into your community from the admission standpoint?
That's correct.
And can you answer a question about UNC's history of exclusion? You mention it several times in your brief, and I'd like to understand whether and to what extent that matters with respect to the diversity interests that you are asserting.
Thank you, Your Honor. So we don't think, we're not pursuing any sort of remedial justification for our policy, but we do think that our university's history is relevant to the diversity analysis in two distinct ways. So first, we think it helps explain why the progress that we have been pursuing is perhaps behind the University of Oklahoma, for example. We have a unique racial history in our state, and all these programs take society as they find it.
I see. So that might account for why the sort of 25-year expiration deadline can't really be blanketly applied because we start in different places with respect to how race has been considered to exclude people in our various communities.
Yes, I agree very much with that statement.
Thank you, Justice Thomas. Anything further?
What's the difference between, what is the percentage difference between a non-racial approach and the approach that you're taking?
So the expert evidence in our case suggests that around 1.2% of the applicant pool as a whole is affected by our race-conscious admissions program. And how that works out in terms of the relevant denominator is the number of underrepresented minorities on campus, which is still fairly small. It's far lower, for example, than the number of rural students that we have, and it's even less the number of first-generation college students that we have. So it's around maybe 10-15%.
So do you think that 1.2% marginal difference is enough of a compelling interest to continue a race-based program?
What we have tried to do is follow this court's guidance, particularly in Fisher 2, but in other cases where the court has said that it is a hallmark of narrow tailoring and therefore a test of constitutionality that we consider race only minimally. And of course, seeking the educational benefits of diversity is also a continuum. We think that we would not face some of the struggles that we do in terms of admitting and enrolling underrepresented minorities if we considered it to a larger extent, but we have chosen to, under this court's precedence, be guided by this court's precedence to consider it only minimally.
So if someone was bringing a discrimination case against the University of North Carolina and the racial difference composition was 1.2%, would they have stated a claim?
I see. Let me just make sure I'm understanding well, so I think that there are, I mean, it goes to the issue of standing generally and what you need to show.
No, just someone is bringing, it's statistical, and they said the difference between the admission of Group A, racial Group A, is 1.2% more than racial Group B. Would that be enough for discrimination?
I think it would be enough to state a claim that someone's candidacy has been affected by a policy. I think one other thing to point out, I think, is that there are other aspects of our policy, as I think Justice Jackson was getting at, that have a reverse impact as well. And we haven't modeled this, but any diversity factor could have a disproportionate impact on the racial composition of the class in some other direction. And so I do think this is one of the major concerns that would arise if Grutter is overruled.
Justice Alito?
I'd like your response to the argument that these racial categories are so broad that any use of them is arbitrary and therefore unconstitutional. So what would you say to, for example, a student whose family came from Afghanistan and doesn't get in because the student doesn't get the plus factor that the student would get if the student's family had come from someplace else? So you would say to the student, well, we don't need you to contribute to a diversity of views at our school because we already have enough Asians. We have a lot of students whose families came from China or other Asian countries. And the student says, well, you don't have anybody like me. I'm from Afghanistan. What similarity does a family background of a person from Afghanistan have with somebody whose family's background is in, let's say, Japan?
So respectfully, what you're describing is the exact opposite of how our process actually works on an individualized basis. We discussed this on page 11 of our brief. There was a Vietnamese student. The admissions officer testified about a Vietnamese student who immigrated to a remote part of North Carolina and thrived in that setting. And she testified undisputed that was a favorable aspect of her application.
That's an individual aspect of the application and something that has to do with her experience. But what is the justification for lumping together students whose families came from China with someone with students whose families came from Afghanistan? What do they have in common?
So I agree that that would be a strange rule, and that is not the rule that this court has established.
Well, then why
It
do
is
you
required-
have them check a box and that I'm Asian? What do you learn from the mere checking of the box?
So we think that it depends on the individual circumstances of that person, but
So you don't need the boxes at all.
So I think that that is not necessarily true on an individualized basis. So to another example, so we, again, as I discussed, we attempt very vigorously to recruit and enroll rural students. And we don't ask them to write their essay about how being from a rural background affects their sense of self and their experiences. But what we say is that person comes with something that we value.
Well, they may choose to write about it, but what's the answer to my question? Why do you have these boxes? Why do you give a student the opportunity to say, this one thing about me, I'm Hispanic, I'm African American, I'm Asian. What does that in itself tell you?
We think that it can, in context, on a individualized basis, perhaps not in every case, but in some cases, give important information about where that person is coming from and what their experiences have been. And really, this goes to the heart of the dispute that we have between the parties. So they say on page 53 of their brief that race says nothing about who you are. And we just don't think that is true when you look at American society as it exists. We think that in the context of everything else that we know about an applicant, it can matter, not always, and there's no automatic plus factor that's given, but it can matter what an applicant's racial background is.
Let me just ask one more related question, and that is the circumstance. This is a real problem, and I've heard it described to me by people who face it. When can a student honestly claim to fall within one of these groups that is awarded a plus factor? So let's say the student has one grandparent who falls within that class. Can the student claim to be a member of an underrepresented minority?
Yes, we rely on self-reporting, and we don't give it.
One great-grandparent.
If that person believes that that is the accurate expression of their identity, I don't think there would be any.
One great-great-grandparent.
I think,
You're going to make me continue to go on.
Right. I think that as we go on, I agree that it would seem less plausible that that person would feel that this is actually capturing my true racial identity. But the same is true for any of the other diversity factors that we
It's family
rely on.
lore that we have an ancestor who was an American Indian.
So I think in that particular circumstance, it would be not accurate for them to say based on
I
family
identify
lore.
as an American Indian because I've always been told that some ancestor back in the old days was an American Indian.
Yeah, so I think in that circumstance, it would be very unlikely that that person was telling the truth. And the same is true for, we rely on self-reporting for all the demographic and other characteristics that we ask for. And there's nothing special about the racial identification on that score, Your Honor.
You get an automatic plus for checking a box?
No.
That's the whole point, isn't it? That checking the box is not what gets you a point.
Right. And I think, one helpful illustration of this point, Your Honor, is, so SFFA's own expert, their own deciles analysis finds that among the most academically qualified students, Asian Americans and white applicants actually have a higher acceptance rate than black students. This is their own expert evidence, and this is discussed at PEDAP 78. As the district court commented, that is a particularly strange result if their characterizations of our admissions process are accurate.
Mr. Park, on this issue of when this will end, 9 states have chosen to rely just on race neutral, completely race neutral, with race being not even a small factor anywhere. Not all of them have been as a result of the people voting. It's been the systems themselves choosing this. Isn't that the case in Florida?
That's my understanding. In Florida, it's an executive order, and there are many states where it's institution by institution. So Georgia, for example, is...
Now, even your adversary said he didn't see the 25 years as a set deadline it was an expectation. What we know, we have 9 states who have tried it, and in each of them, as I mentioned earlier, white admissions have either remained the same or increased, and clearly, in some institutions, the numbers for underrepresented groups has fallen dramatically, correct?
That's my understanding, yes.
All right. What we also know in those 20-odd years is that racial disparities has grown dramatically as well. Segregation has grown. The disparity between incomes has grown. And so has the effects of these things in terms of the resources that underrepresented groups receive, correct?
I believe that that matches much of my understanding, yes.
And I understood that the district court found that UNC, on a continuing basis, reassesses its race-neutral factors and is constantly monitoring whether they've reached some form of representation adequate for their system regularly, correct?
Yes, yes. And
that was your point, which is we can't tell you it's going to end in 2029 or 2030, but we're not just assuming it will continue. We're looking at it regularly to see when it ends, correct?
Exactly, Your Honor. And there really is a quite extensive infrastructure that the university has established to continually monitor our progress on this score. I mean, a whole range of committees, but the committees actually include some of the world's leading experts on doing these kinds of qualitative assessments. And so it's something that we are continually pursuing. And right now, there are many other projects ongoing for us to try to reach the day where we can find a viable race-neutral alternative.
Thank you, counsel.
Justice Kagan? Justice Gorsuch?
I'd like to ask you just a hypothetical about narrow tailoring, because we're in strict scrutiny land here, and the university has to demonstrate it's narrowly tailored, race is narrowly tailored, and diversity is the rationale you've asserted before us. Universities also have all kinds of other plus factors they use, like for legacies of alumni, for donors' children, for squash players, we learned there are plus factors, because we need those too. And I guess I'm wondering, suppose a university, a wealthy university, could eliminate those preferences which tend to favor the children of wealthy white parents and achieve diversity without race consciousness. Would strict scrutiny require it to do so?
If I may, I'd like to just make a threshold point that those are not, that doesn't match our facts.
I understand, counsel, I understand the hypothetical is not your case and you don't like it. Right. I got it.
Right.
Okay, but if you could just take a shot at it.
The absolutely critical point, if I could just very quickly, is that it's undisputed that legacy status does not affect everyone.
I understand, counsel.
So, yeah.
I do understand, and I appreciate that, okay? I've had to face many hypotheticals at a lecture and I didn't like. Yeah. But let's just take the hypothetical. We're in strict scrutiny. Compelling interest has to be established. Wealthy university, okay? And it still prefers all of these, and give checks to these kinds of persons, not for their academic merit, but because they would bring diversity in the form of a squash team. Or they might bring a new art museum, we heard, for example. Oh, we have to admit that kid because his parents are going to donate an art museum, okay? Suppose the university could achieve race neutrally, just suppose, race neutrally, all of its diversity objectives, if it just eliminated those preferences, would strict scrutiny require it to do so?
I would say yes if 3 things are true.
All right.
First, that alternative would have to also match the compelling interest, because as I mentioned, this court has never recognized a compelling interest.
Is there a compelling interest in a squash team composed of really good players or a new art museum? Is that what you're suggesting?
No, Your Honor, that's not what I'm suggesting.
Okay, so there's no compelling interest in those things you're telling us.
Right, and so if the alternative didn't have an effect on broad-based diversity, not solely racial diversity, which is our main objection to the RNAs.
We'd have a great socioeconomic diversity, we'd have great religious diversity, we just would have a crummy squash team and no art museum. Then what?
Right, and I think The other condition I would try to sneak in is that there wouldn't be a material negative impact on the academic environment. And third is that
So the GPAs are good. So these
Right.
kids that are being admitted, same GPA, same SAT. Then what?
right, and I guess the third would be that the specific goal of racial diversity is not significantly undermined. And so, yeah, with those three conditions, I agree.
Okay, thank you.
Justice Kavanaugh?
How are applicants from Middle Eastern countries classified, from Jordan, Iraq, Iran, Egypt, and the like?
My understanding is that just like other situations where they might not fit within the particular boxes on the common application, that we rely on self-reporting, and we would ask, they can volunteer their particular country of origin.
But if they honestly check one of the boxes, which one are they supposed to check?
I do not know the answer to that question. What I can say is that if a person from a Middle Eastern country self-discloses their country of origin, it would be considered in the same way that we consider any box that matches one of the boxes that's available on the common application, which is it would be an individualized holistic analysis. And I can genuinely say that there would be a similar positive analysis in terms of the contribution that a student like that would contribute. And we do track, in particular, again, after the admissions process, religion and country of origin and that sort of thing.
Thank you.
Justice Barrett?
Just have one more question about endpoint. Alan Bakke would have been born into a pre-Brown world, and then we have 25 years, we get to Grutter. Grutter says, we cannot imagine, as I read that language before, this is dangerous. We can't imagine it's going to go on more than another 25 years. And you've been pressed a little bit about what is the endpoint for you. This distance of time, this 50 years since Bakke, suggests accurately, I think, that achieving diversity and diverse student populations in universities has been difficult. What if it continues to be difficult in another 25 years? I take it that you, because you've repeatedly said that the 25 years is aspirational, and you told Justice Kavanaugh it wasn't a holding, that you don't think that University of North Carolina has to stop in 25 years, at the 2028 mark. So what are you saying when you're up here in 2040? Are you still defending it, like this is just indefinite, it's going to keep going on?
I think that Grutter is helpfully self-limiting in that it requires aggressive and enthusiastic adoption of race-neutral alternatives. And I think it's a dial, not a switch. And the progress that we've made since Grutter has shown that at the University of North Carolina, we have dialed it down substantially. The expert evidence in that case, obviously they're different institutions, was that around 70% of the underrepresented minorities in the institution at issue in Grutter, it was determinative that they had a certain racial background. And here the number is far smaller, and we anticipate that we would be able to dial it down to zero. And I think the reason why I feel confident in that is because of Grutter's requirement that we continue exploring doggedly race-neutral alternatives. And even since the record has closed, the University of North Carolina has done so and is continually attempting to monitor it.
Thank you.
Justice Jackson?
Yes. So we've heard a lot about checking the box in the context of the claims that are being made in this case, and I'm concerned that that I might be confused about the implications for that of that. So first of all, this box is on the common application, right? It's not on North Carolina's form of any sort. Every student who fills out the common application form has the ability.
Correct.
Okay. And so have you seen one of these forms? Because I don't know if they're in the record in this case. Is the common application in the record somewhere?
Yes, it is. I believe it might be completed application, so it might be the sealed appendix.
All right. So we have this form that all students who are applying to any college can use, and I understood the form was basically, reduced to tell us about yourself. That you put all sorts of things. It's not a separate piece of paper that says this is about race. It's just who are you, And in the context of that, students check and write in all kinds of things. Am I wrong about that?
Yes, the form has evolved over time,
Okay.
and the current form, I can't say for certain the forms that are in the record, but the current form does allow for more self-description, so the student with the background that Justice Kavanaugh mentioned would be able to fully describe.
And so any form of race, it's not like we have to care so carefully about what are the categories in there and how anybody, a Caucasian student could check Caucasian. We're just telling who we are as a general matter, right?
Yes, Your Honor.
Okay, so everybody who wants to, does North Carolina require anybody to fill out the box that has to do with race
No.
on this form? All right, so there may be some people who don't put anything for race.
There certainly are, yes.
All right. Isn't the question then what North Carolina is doing with that information? Because presumably just knowing that you have people from different races applying to your school is not working an equal protection violation, is it?
I agree with the sentiment behind that question. I think the language of racial classification has been used, and it sincerely does not reflect how our admissions process works. It's race consciousness. And
Right, so you're not like doing something different with the people who check the box and put certain categories. Everybody then goes into the holistic process of looking at all kinds of other things so that race is never the only criteria that a person is evaluated with respect to. Is that right?
Absolutely. And we think the district court made findings in this regard.
And even if you check the box, I'm an African American, I'm a Latino, and all the other things, I live in this place, et cetera, even if you check that box, in North Carolina's system, do you get a point automatically for having checked that box?
Absolutely not. Absolutely not.
And is anybody who did check the box, are they automatically entered or admitted into the university as a result?
No. And,
All right, so final question. Given a holistic review process like that, is there a risk of treating people differently by not allowing some applicants to talk about that aspect of their identity? I hear a process in which there's a form that says, tell us about yourself, and people can put all sorts of things. I'm Catholic, I'm from, Los Angeles, I'm a Latina, whatever. But now we're entertaining a rule in which some people can say the things they want about who they are and have that valued in the system, but other people are not going to be able to, because they won't be able to reveal that they're Latino or African American or whatever. And I'm worried that that creates an inequity in the system with respect to being able to express your identity and, importantly, have it valued by the university when it is considering the goal of bringing in different people. Is that a crazy worry, or is that something that I should be thinking about and concerned about?
Not at all, Your Honor, not crazy at all. We are very concerned with that issue, Your Honor, that if race is the one thing, or if there are other factors that are subject to heightened scrutiny, if only those factors cannot be considered in the admissions process, then anyone with a background or perspective that doesn't fit into one of these categories will have an advantage in our admissions process. We think, just as Mr. Strawbridge said, that it's a mathematical exercise, and if you artificially say that only certain people can't tell the university about some of their important aspect of their background, but underrepresented minorities are barred from doing so, or all people can't discuss their racial background, then certain applicants will be subject to a disadvantage.
Thank you.
Thank you, counsel. Mr. Hinojosa?
Mr. Chief Justice, and may it please the court, this court must stand firm in its commitment to ensuring racial equality and equal opportunity by affirming the Bakke-Grutter framework. From the Sweat and Brown cases through Bakke and Grutter, this court has recognized the paramount roles that integrated education and cross-racial interactions play in building a true democracy, where pathways to leadership are visibly open to all qualified candidates. Brown attempted to shut down this nation's terrible caste system, but stark racial inequalities persisted and stunted this nation's growth. Enter Bakke and Grutter, which have helped universities open the doors of opportunities to highly qualified students of color who are often overlooked in a process that typically undervalues their talents and perspectives. Racial diversity and its attending social and academic benefits help all students to be better prepared to work and live together and make this nation better as a whole. We have made progress, but many colleges are not there yet, including UNC, which grapples with over 160 years of exclusion and its present-day effects. I welcome the court's questions.
Mr. Hinojosa, if this were a Title VI case and there was an allegation of discrimination against the University of North Carolina, who would bear the burden of coming forward?
Is it within the strict scrutiny?
No, just Title VI claim of discrimination.
A normal claim of intentional discrimination,
Exactly.
Your Honor. I would understand that the plaintiff would have that burden to demonstrate.
To come forward initially, but then when the plaintiff makes his or her showing, then what? What's the duty of what's the burden on the accused?
It's not entirely clear from the case law that I'm aware of, Your Honor. Ordinarily,
Is there any case where the court has deferred to the university or to the alleged discriminators' policies?
So, for example, I don't know whether or not this has been answered directly in Title VI case law. Title VII case law, Your Honor, yes, then the burden would shift to, in that case, it might be the employer.
What's interesting here is I cannot think of another area or another case where the court deferred to the alleged discriminator on something as important as compelling interest. We don't do it in Title VI, we don't do it in Title VII. You have McDonnell Douglas, you have Arlington Heights, and this is a first. And what I'm asking you is, isn't it odd that you have a framework in Grutter that defers on the critical issue in the case of compelling interest?
No, Your Honor. I think it's entirely consistent, with this case, with this court's framework in judging strict scrutiny. Let me make a couple of points first. One is on the discrimination point. This is not discrimination per se. The limited consideration of race in a holistic fashion, as this court has approved, is a limited classification that is subject to strict scrutiny, but that whole strict scrutiny process is trying to filter out whether or not we have a legitimate purpose for this or not, and whether or not there's a compelling interest that may be sought and achieved, through narrowly tailored means.
Let me ask more specifically. If this case involved a school district in Virginia in 1960 that is alleged to be discriminating, would this court defer to its assertion that the races do better if they're segregated?
Absolutely not, Your Honor, but that's not this case. This case is about a limited classification involving a compelling interest.
That's not what I'm talking about. I'm talking about the court's deference. In that case, the court would put Virginia to the test. In this case, it does not. And I'm asking you why the difference.
In this case, Your Honor, it actually is. The burden is the university has a high burden of demonstrating its compliance with this court's standard under strict scrutiny. The only narrow area that this court's framework, as I understand it, has deferred to the university is establishing its objectives. But the whole framework still requires a well-reasoned explanation for seeking for its own compelling interest. It requires the university to demonstrate that there are no race-neutral alternatives that will work about as well. And so that burden is still heavy on the university to demonstrate compliance with this strict scrutiny framework.
Mr. Inosa, In this case, the petitioner never challenged that diversity was a compelling interest, correct? Their own experts said that racial diversity was an important, compelling interest, didn't it?
That's correct, Your Honor, in the trial below.
But it doesn't, that deference, whatever it's defined at, didn't stop you or the state from meeting its burden of showing why that was a compelling interest, correct?
That's correct, and there's a 155-page opinion in this case based on the facts and based on significant analysis and testimony from the University
court below
administration.
carefully examined whether the university's articulated interest was clearly identifiable, measurable, and precise, didn't it?
Yes, Your Honor.
So it's not much deference if I don't even know why that word's being used, correct?
That's correct, Your Honor.
Now, in terms of that information, you put on extensive evidence about the history of racism in UNC, correct?
That's correct, Your Honor, including a history of its own founding to help educate the owner, the children of slave owners.
And it went through de jure segregation way after Brown, correct?
Yes, Your Honor.
Until the 1980s. But you didn't stop there, did you? You presented evidence about the continuing Confederate relics that exist on campus?
Yes, Your Honor.
The continuing white supremacy marches that still go on?
Yes, Your Honor.
The racial epithets that minority, that underrepresented groups are experiencing to this day?
Yes, Your Honor.
So given that your adversary says that race can be used to correct past discrimination, why isn't it in this particular university appropriate to use race as one factor among many to address its history of racial discrimination and its continuing effects on campus?
Yes, Your Honor, if I understand correctly, I do want to clarify one point, is that we are not suggesting, as I understand the university is not either, is that the limited consideration of race in this case is being used as a remedial order to address that. The reason for the importance of those present-day effects of that past discrimination is articulated through the compelling testimony of the respondent students in this case about how those present-day effects affect their own value on campus, looking at these Confederate relics and the like and seeing these white supremacists come on to campus marching, which is certainly a First Amendment right, but it doesn't ignore the fact of how those students feel during those moments. But it also, and that in turn impacts their own education within the classroom. So it's not just standing alone that you have hypersensitive students, reacting to these marches and these other activities on campus, but it's also making sure that about the impacts in the classroom that it carries forward to, and also how it impacts recruitment. When students of color, and they see less than 100 black males accepted and enrolled at UNC in the 21st century, when they see that and they hear about all of these present-day effects going on, that impacts their own decision on whether or not they might apply, whether or not they might actually end up going to the great university of the University of North Carolina.
Counsel,
that again is the...
If all of the individual incidents and artifacts that you mentioned were not in this case, and if the university were a state university that never practiced segregation, would you say that the case would come out differently?
It may, Your Honor, and that's how and why we should not have an across-the-board policy that all of a sudden jettisons the important limited consideration of race that this court has approved.
So you would perhaps endorse a system in which a state university in a state that never had de jure segregation would be prohibited from doing what North Carolina is doing?
Yes, because the important point here is whether or not the educational benefits of diversity have been established by that particular university. And so here at the University of North Carolina, of course, it matters a lot because it affects recruitment and retention and the like. But at another university where it may not have been, a part of its history, it's still the important piece here is whether or not the university itself can establish its own educational benefits of diversity and satisfy that through narrowly tailored means. The University of Michigan, in the Gritter case, is a good example of that. I won't pretend to know the history of the state of Michigan, but and I know that they were fraught with, desegregation problems themselves, within districts, but whether or not that was a remnant of the state's own de jure segregation, I don't know, but that would be a good example.
Thank you, counsel. You've mentioned the benefits, of course, in diversity, but amici on the other side have argued that one consequence of the school's consideration of race is that it sends the message that race is something you should consider down the line. In other ways, student activities, other sorts of areas, that they get the message from the beginning, race counts, and they carry that forward into other areas where there may not have been a history of discrimination that would, in your terms, justify it. Do you have a response to that?
Yes, Your Honor. The research, and there's some of the research that is shown, and I apologize if the court isn't quite getting here, but what I understand the court is inquiring about is, some of the particular stigma that might be attached to...
No, it was the fact that the school is telling students race matters in admissions, and that the students may learn from that lesson that race should matter in other areas where perhaps it doesn't have the same justification as it would have under your view on admissions.
Yeah, so 2 points, Your Honor. One is that there's no evidence in this case of the University of North Carolina's own decision to enact race-conscious admissions had led to any negative consequences, much less the negative consequences that you've shared here.
Do you know, this may be an unfair question, is race a consideration in the formation of other types of activities that students are engaged in? I get the sense from the briefs anyway that race permeates a lot of what happens at the university, and you're shaking your head in a way that you don't agree with it.
Well, Your Honor, it is a bit of reminds me of a storybook when I was a child, Henny Penny and the Sky's Falling argument, because they're blaming that just about everything is caused by race-conscious admissions. But in fact, if you look at the research, for example, on the issue of stigma, both internal and external stigma, and this is referenced in the AERA brief, it actually shows that race-conscious admissions programs at, universities that have race-conscious admissions programs actually have lesser degree of stigma attached, both internal for the student and external, what they're hearing from other students, than states with bans on...
Counsel,
I'm sorry.
I'm not talking about stigma. I'm talking about student groups taking its cue from the university and saying, we ought to take race into account when whatever we're doing.
And again, Your Honor, there's no evidence in this case of how that correlates to any consideration of race at UNC or any other university.
Thank you, counsel. Justice Thomas?
Mr. Hinojosa, I may be tone deaf when it comes to all these other things that happens on campus about feeling good and all that sort of thing. I'm really interested in a simple thing. What benefits academically are there to your definition or the diversity that you're asserting? Specifically, I know kids feel, you've got studies that show that people feel better and they don't feel isolated, on and on. I'm focusing on what you went to college to do, to learn something. Do you have anything that demonstrates that?
Yes, Your Honor. And you're asking for the specific educational benefits of diversity?
Yes.
Those would include, for example, fostering innovation. And there's plenty of testimony in this case from chemists, professors at UNC and from students themselves who have understood the importance of diversity in helping to foster to foster innovation, to broaden perspectives, engaging in students. And this is all the way harkens back to the Sweat v. Painter case and the McLaurin cases, where they acknowledged that racial interactions and dialogue between students helps better prepare them for the world that they're going to work and live in. There is the reducing stereotypes. For our own students who testified in this case, it's played an incredibly important role in their education. And when you help reduce stereotypes and isolation, you end up impacting the educational environment for all students because they are sharing their perspectives. They're not necessarily feeling isolated as the spokespeople. And so those are among the several educational benefits of diversity that have been recognized and that we, as the respondent students, support.
Justice Alito?
You make some very good points in your brief, but reading it, I was struck by the fact that the word Asian does not appear one time in your brief. Yet Asian Americans have been subjected to de jure segregation. They have been subjected to many forms of mistreatment and discrimination, including internment. So do you have anything to say this morning about the interests of students of Asian background and how your arguments impact them?
Yes, Your Honor. So 2 points. One is that discrimination against Asian Americans is wrong. It's bad. We do not condone it at all. But 2, our brief actually reflects the record in this case. There were no claims developed by petitioner involving the mistreatment or maltreatment of Asian American students. And I think that was one of the problems that happened with the first brief, is that they conflated their arguments against Harvard, which Mr. Waxman will adequately defend shortly. But those arguments conflated the issues. There's no racial balancing claim against UNC. There's no allegation of quota. There's been a lot of talk about quota in this case. There's no claim about that. There's no claim against UNC involving the intentional discrimination against Asian American students vis-a-vis white students or other students. So that record actually doesn't exist.
So what is your response to the simple argument that college admissions are a zero-sum game? And if you give a plus to a person who is falls within the category of underrepresented minority, but not to somebody else, you are disadvantaging the latter student.
And Your Honor, that's an excellent point, but the record actually bears out about how, in this case, how the holistic admissions plan does end up operating. And it is where an individualized consideration is being made on a student's own talents, on a student's own achievements.
So you're saying that race in and of itself has no effect at the University of North Carolina?
Absolutely not, Your Honor.
Okay, then you would have no objection to an opinion from this court saying you may not consider race. You may consider other things, but you may not consider the mere fact of race, period. You would have no objection to that.
Your Honor, I don't know if I'm answering your question with a negative and a double negative here, but I do want to make clear that we fully support the limited consideration of race as it has been authorized by this court.
Well,
again,
then
it is only on an individual.
I don't understand your answer. Either if it's irrelevant, then you shouldn't care whether it's ruled out.
And we're not, if I'm articulating that, Your Honor, I'm not meaning to. We certainly believe that race within the context of an applicant may be considered as a plus factor. That's not
race in
only
itself may be considered a plus factor.
Yes, Your Honor.
And therefore, those who don't get the plus factor have what is essentially a negative factor.
No, Your Honor.
It's not the same thing?
No, Your Honor, it's not, because it's looking at the whole applicant as they apply within their whole application and their resume, et cetera.
Suppose you have a race, 2 people are in a race, and you give a plus factor to one of the runners. So that runner gets to start, well, if it's a 100-yard dash, let's say it gets to start 5 yards closer to the finish line. The one who doesn't get that plus factor is disadvantaged, right?
That would be in that case, but that case is not here. There are no bonus points that are provided to any applicant at the University of North Carolina. That is fully prohibited by this court's decision in Gratz, and we're not suggesting that it should be reinstituted.
Justice Sotomayor?
Counsel, a race is sort of an artificial creation, right? It measures how fast you can go from point A to point B, correct?
In some respects, yes, Your Honor.
All right. But what colleges are doing is not saying, they're not looking at the runners and putting them in this race. They're looking at the applicant, at the student as a whole measure, correct?
Yes, Your Honor.
And if we said that applicants from white schools can start here, if applicants from socioeconomic schools don't start at the same place, you're going to push them back, right?
Yes, Your Honor.
So what the schools are doing is looking at all the factors to try to put the students at the start as equals, correct?
That's correct, Your Honor.
And race is not defining in that. It's not the one factor at any application that makes a difference.
There is zero evidence of race playing a decisive factor for any applicant. There is zero evidence of any student who was accepted under the race-conscious admissions plan, regardless of race. There is zero evidence of any student being penalized for their race, or that that student, if they were admitted, that they were not qualified. They all qualified on their individual merit.
Thank you, Kevin.
Justice Kagan? Gorsuch? Justice Kavanaugh? Justice Barrett?
One question. One difference between your brief and your position and the University of North Carolina is that from the student's perspective, and you were getting at this in some of your answers to Justice Sotomayor early on about Confederate statues and the presence of white supremacist groups, is that from the student perspective, students, the educational benefit to the students might be in the form of counteracting feelings of isolation, sticking out, not being supported. In light of that, I'm wondering if you have anything to say about affinity groups and affinity housing. I think one thing, at least insofar as I'm aware, at the time Grutter was decided, and certainly Bakke, that kind of a phenomenon where you have groups, say, where, Black students and allies can live, or, Black student groups, same for, Hispanic groups, et cetera, was not a phenomenon that was around then. And I think one of the benefits is that it allows minority students to band together to reduce some of the feelings of isolation that you've been talking about. Do your clients have a position on that, and whether that would be, because whatever we say, or however broadly we wrote this opinion, that rationale about the educational benefits of diversity presumably might have some bearing on those questions that are post-admission questions.
Yes, Your Honor. So, those do invite, very difficult questions, and I think that's how and why a potential colorblind ruling from this court, may disrupt things even further, but also about how, certain conditions may apply on a case-by-case basis. So may not be making too much sense with what I just said there. But, in the terms of affinity groups, for example, research shows that affinity groups have incredible benefits, not just, for its own members, but in helping the broader community understand, for example, racial and cultural issues, that they might raise. It's not my understanding that there are any affinity groups, especially, for example, Black student associations, that
I'm really thinking mostly about affinity
students.
housing. And I understand Chapel Hill does not have it, but UNC Wilmington does. Would your clients have a position on affinity housing?
I do not know, Your Honor.
Okay, thank you.
Thank you.
Justice Jackson?
Can I just quickly return to Justice Alito's hypothetical, which I think is a little bit helpful in trying to pinpoint a problem that I've been having. It seems from the race hypothetical that if there was only one basis for giving someone a boost, and that basis was race, then I see disadvantage absolutely to anyone else who's not an underrepresented minority who can get that boost. But I understood that we have here a program in which there are at least 40 different bases for being able to get a boost. And not everybody who is an underrepresented minority gets a boost. So it's really hard to figure out if anyone is being disadvantaged in a system like that. And that's where I was worried about standing, because I'm trying to understand how the system is operating to actually advantage minorities in a way that is harmful to anyone else in this system.
Yeah, and I think that attributes to the careful cue that UNC has taken to this court's decisions in Fisher 2, making sure, universities find themselves in this Goldilocks problem about, considering it too much or too little. The university.
But there are other considerations, is the point. Everyone can get a boost for all sorts of reasons. Minorities don't automatically get a boost under this system, so it's hard to know whether anyone's being disadvantaged from the mere fact that a minority could get a boost in this environment, right?
That's right. And the evidence also bears it out at Petition Appendix 78, where the evidence showed that hundreds of white students with lower combined GPAs and SAT scores were admitted ahead of higher performing Black students, Latinx students who went to UNC. And I think that bears the hallmark of the type of individualized consideration that this court wanted.
Thank you, counsel.
Thank you.
General Preliger.
Mr. Chief Justice, and may it please the court. For decades, this court has rightly recognized that student body diversity is a compelling interest that can justify limited consideration of race in university admissions. That holding recognizes a simple but profound truth. When students of all races and backgrounds come to college and live together and learn together, they become better colleagues, better citizens, and better leaders. That truth is vitally important to our nation's military. Our armed forces know from hard experience that when we do not have a diverse officer corps that is broadly reflective of a diverse fighting force, our strength and cohesion and military readiness suffer. So it is a critical national security imperative to attain diversity within the officer corps. And at present, it's not possible to achieve that diversity without race-conscious admissions, including at the nation's service academies. The military experience confirms what this court recognized in Grutter, that in a society where race unfortunately still matters in countless ways, achieving diversity can sometimes require conscious acts by our leading educational institutions. The court's precedents strike a careful balance. Race can be considered if truly necessary, but only as one factor in a holistic admissions process that prioritizes and values diversity in all of its dimensions. The court should adhere to that balance today.
Once again, would you tell me specifically what is included in diversity for the purposes of education, achieving educational benefits?
Yes, Justice Thomas, and if I could, I'd like to use the service academies as an example here and explain to you the concrete educational benefits that the service academies are seeking to obtain through their use of race-conscious admissions. And it really falls into two separate categories. One is the suite of benefits that the court's precedents have already recognized, things like increasing cross-racial understanding, which can have direct impacts on challenging stereotypes and assumptions and leading to positive developments with cognitive development that can be perceived as early as a student's second year in college. It can include things like reducing a sense of racial isolation and alienation, and that has proven educational benefits as well in terms of encouraging greater participation by minority students in a classroom environment. And then the second category that I would point to, and this traces directly from Grutter as well, is the court's recognition that in order to train a set of leaders with legitimacy in the eyes of the public, it is necessary to have our leadership broadly reflect the diversity of our country. And that is a critically important interest in the military, because we have had experiences in our past where the officer corps and its racial composition did not reflect the diversity in enlisted service members, and that had caused tremendous racial tension and strife. So that is the set of benefits that the service academies are seeking to obtain.
And why can't you do it through race-neutral means? Because I think everybody has agreed, all our cases indicate that race-neutral means are better if one can achieve those kinds of objects that you were talking about that way. So why can't you after 20 years?
It's absolutely correct that it's incumbent on universities and on the service academies to take account of race-neutral alternatives and to put those into practice where they can achieve diversity, and that's what the service academies are doing. They have done things like trying to bolster outreach efforts to underserved communities, to try to solicit additional nominations from congressional districts that have traditionally sent fewer cadets to the academy. They've looked into other alternatives like socioeconomic preferences, but West Point discovered that that would actually increase the number of white men at the academy. And other race-neutral alternatives just don't work in this context for the service academies. For example, a top 10% plan wouldn't work because the service academies have to draw from a nationwide applicant pool, and they also have to prioritize and value other characteristics like physical fitness and leadership potential. So I can't say that we are able to get there all the way right now with race-neutral alternatives. That's what the service academies have seriously studied, but we are trying to make progress toward that goal.
General, you have emphasized the service academies today, and you did in your brief, and Government Counsel and Grutter did as well. Are you linking yourself to Harvard and UNC? In other words, you rise or fall with their case?
Well, Mr. Chief Justice, we certainly think that it's critically important for universities throughout the nation to be able to prioritize the educational benefits of diversity, and the ROTC programs are also a compelling interest for us here that exist at those civilian institutions. But I guess if what you're asking me is whether we think the military has distinctive interests in this context, I would say yes, and I think it's critically important for the court in its decision in these cases to make clear that those interests are I think, truly compelling with respect to the military.
So in that situation, I suppose it depends how significant you think those distinctions are. It might make sense for us not to decide the service academy issue in this case?
Well, I would certainly ask the court to take account of those distinctive interests and I think to recognize the compelling interest and the critical national security interest that I think.
I guess I'm saying I would have thought that you might want to distinguish yourself in order to preserve arguments that are particularly applicable, if there are such arguments, to the service academies, rather than take the position here, which is you're going to be bound by whatever we say with respect to the other universities.
Well, it is critically important to the military to be able to achieve diverse student bodies in the service academies, but it's also critically important because actually more officers come from ROTC programs to try to protect and preserve space for universities to also achieve the educational benefits of diversity and provide the path to leadership that inhere in those programs as well.
What about a college that doesn't have an ROTC program?
I'm sorry, Justice Alito, I didn't hear that.
Yeah, what about a college that does not have an ROTC program? Would a plan that would be permissible at a college that has a program be impermissible at the latter, at the one that doesn't have the ROTC program?
We're not asking the court to draw that distinction, and our interest here, I think, does extend more broadly to other federal agencies, to the federal government's employment practices itself, and to having a set of leaders in our country who are trained to succeed in diverse environments.
Well, then I don't understand the relevance of what you're saying about the link between college education, either at a service academy or a school with an ROTC program, and the needs of the military. If it doesn't matter whether the school has no ROTC program and therefore trains no officers.
Well, Justice Alito, I was trying to focus on the specific question I understood the Chief Justice to be asking about the military's critical interests in this context, and just trying to make the point that it's not just confined to the service academies, but we believe deeply in the value of diversity and in universities being able to obtain the educational benefits that correlate with diversity.
Well, what you say about the military is something that we have to take very seriously. You represent the entire executive branch, including the military, and we have to presume that you are reflecting the views of the military. But what do we do with the fact that the United States was on the opposite side in the Harvard case when the case was in the lower court? And what do we make of the arguments that were made by your predecessor in Grutter? Were they insensitive to the needs of the military? Only you have accurately represented the interests of the military?
Well, let me take each of those questions in turn. With respect to the Harvard case, it's true that the United States participated below on the side of petitioners, but only with respect to the factual record and what we thought, my predecessor thought the evidence showed in the case on the factual issues. We did not take a different position on the legal interests here or assert a different interest on behalf of the military. With respect to the Grutter case, There, too, the United States did not take a position to call into question whether diversity could qualify as a compelling interest in this context. Instead, the participation of the United States was confined to the narrow tailoring prong of the analysis and whether race-neutral alternatives were permitted. And my predecessor was asked specifically in that argument whether he thought that the military's and the academy's race-conscious admissions programs were unconstitutional, and he declined to say that they were. So I do not think that there is a distinction that's been drawn. And it has, in fact, been the consistent judgment of our senior military leaders across the decades and across administrations, including in the last administration, that it is critically important to our national security to have a diverse officer corps. So that has been a constant and a through line here.
General, what was the factual basis of the prior administration's support of petitioner here? It was on what factual issue?
It was on the factual issues with respect to what the evidence showed concerning the intentional discrimination claim. And I should be clear that this was only in the Harvard case. It wasn't in participation in this case involving UNC.
And it did participate here. Didn't it put a brief in?
Not in the UNC case. I don't.
So it was only
in the
Harvard.
Harvard case.
Right.
And I guess what I would say about that, Justice Sotomayor, is it's true. My predecessor took a different view of the facts. The district court rejected that view, and the First Circuit affirmed the district court's factual findings. So as the case comes to this court, it falls within the court's two-court rule about usually deferring to the current concurrent findings of two lower courts.
Now, virtually all of the states that have banned consideration of race in any respect experienced a dramatic drop in enrollment of unrepresented minority students, particularly black students and Native American students, but particularly black students. And even that drop lasted in most of those institutions, if they're not continuing now, at their most prestigious colleges and universities, correct?
That's correct.
So there is a
Respect to
high
Michigan and-
price to pay by banning the minor use of race in college admissions, isn't there?
I agree with that, Justice Sotomayor.
And that means that there's a diverse, there's lesser number of diverse graduates that enter the pipeline, not just to the government, but to government departments, to the private sector. Many of them require higher education, and so that pipeline is being reduced, correct?
That's correct.
So in the end, our colorblindness, whatever that means, because our society is not colorblind in its effects, that comes as a high cost not only to UNC and to the state and to the nation as a whole, correct?
That is correct. And I think, again, to return to the example of the military, it's the pipeline question is critically important there because the military has a closed personnel system. And what that means is we don't do lateral hiring. And the individuals who are entering college today, the individuals who are participating in ROTC programs today at civilian institutions or who are admitted to the service academies today are the closed universe of individuals who are going to be eligible for leadership in the military in 20 and 30 years' time.
So if we overrule Bakke, Grutter, and Fisher, the diversity admissions programs across the nation based on those cases will have to be reformulated.
Yes.
In every instance. We will have to work affecting countless existing programs.
Correct.
We're reducing underrepresented minorities.
Yes.
We are depriving others who are not there of the benefits of diversity.
Yes.
And we're doing all this because race is one factor among many that is never solely determinative, correct?
Yes.
Seems like a lot to ask.
But I do want to emphasize to the questions about whether this will end and the questions that Justice Barrett and Justice Kavanaugh, you were asking about Grutter's 25-year context, that I do think that eventually there is an endpoint in sight, and it comes directly from the court's narrow tailoring doctrine in this area. I think that diversity in higher education is absolutely a compelling interest, and it will remain so. That is constant. That's not going to change. But our society is going to change in ways that enable more and more universities and colleges to try to achieve the benefits of educational diversity without having to take race explicitly into account.
Grutter gave us a number. You going to give us a number?
I can't give you a precise number, Mr. Chief Justice, but I can say that I think that our society has made some progress toward that goal. And there are states today that do not take account of race in college admissions. There are universities that don't take account in college admissions, and some of those institutions have still been able to achieve diverse student bodies. And so we are not here to suggest that every college and university in the country needs to have race-conscious admissions in order to achieve these goals. The fact that there's been progress along these lines, I think, shows that Grutter is working. It shows that as our society continues to make additional progress, this court's observation there will come to fruition, that we will still be able to achieve those benefits, but we don't need to explicitly take account of race to get there.
That's very different from what Justice O'Connor said. She said race-conscious admissions programs must be limited in time. That was a requirement. So that part of Grutter should be disregarded?
No, not at all. This court has made clear and re-emphasized in Fisher 1 and Fisher 2 that universities are under a constant obligation to evaluate their policies. They cannot adopt race-conscious admissions and just sit back reflexively and let that play out forever into the future. Instead, they need to continuously reevaluate whether progress has been made such that they can use race-neutral alternatives to achieve the same goals. And I think that the court has not retreated from that aspect of Grutter, but that it would be incorrect as a matter of constitutional principle to instead understand Grutter to have set a firm expiration date on the nature of the compelling interest here.
And as to the nature of the compelling interest, you've made a very convincing case on behalf of the military. I'm wondering whether if we had somebody representing law firms or representing medical facilities or representing businesses in America or representing any of the wide variety of institutions that are critical to the well-being of this country, whether they might make a similar case. Obviously, the particularities would differ, but that the essential nature of the argument would be the same.
That's absolutely correct, and you do have many of those entities participating in this case as amici and supportive respondent to explain how critical it is for them to have access to a pipeline of students who have been trained in diverse environments and who themselves broadly reflect the community. So I think it's absolutely the case that the business community, that every aspect of society would feel the shock waves if this court were to retreat from Grutter now.
Thank you, Counsel. Justice Thomas? Justice Alito? Ms. Kagan?
I want to ask on a completely different question, but one notable thing about the argument here is that on both sides, there's been very little discussion of what originalism suggests about this question. And so I just want to ask, what would a committed originalist think about the kind of race consciousness that's at issue here?
I think that an originalist would think that this is clearly consistent with the original understanding of the 14th Amendment. The universities have come forward with powerful evidence that surrounding the time of enactment of the 14th Amendment, there were federal and state laws that took race into account for purposes of trying to achieve the central premise of the 14th Amendment to bring African American citizens to a point of equality in our society. And I think what's so notable, if the court is focused on history here, is that petitioner has come forward with essentially no history to support this colorblind interpretation of the Constitution that would make all racial classifications automatically unconstitutional. There's nothing in history to support that, and it takes aim not only most directly at cases like Bakke and Grutter and Gratz and Fisher in this case, but also at the court's entire structure here of applying strict scrutiny, specifically to take into account when a racial classification might serve a compelling interest and be necessary to achieve that interest.
Justice Gorsuch?
I'd like to focus for a moment on the statutory questions, one I raised earlier. I'd like your thoughts on it. We have both a constitutional claim but also a statutory claim, Title VI. And I understand our precedents have often conflated the two. But put that aside for the moment. Justice Stevens made a powerful argument in Bakke that whatever the 14th Amendment permits or does not permit, Title VI's language is plain and clear, just as Title VII is. And Title VII does not permit discrimination on the basis of sex, and Title VI does not permit discrimination on the basis of race. Can you help me with that?
Sure, Justice Gorsuch. So I think that the court in Bakke and Grutter correctly interpreted Title VI. The statute
Where did Justice Stevens err?
in not recognizing that the term discrimination in this context is ambiguous. And I think that the legislative history therefore carries force in this context.
We didn't find it ambiguous in Bostock. Why should we find it ambiguous now?
Well, I think that the statute doesn't define.
Were we wrong in Bostock?
No, I'm not suggesting that. But Justice Gorsuch, I know you asked me to put to the side that the court has already resolved this issue. I just would emphasize
All right, you're going
that
to go back to that.
we're talking about a statute here. Statutory stare decisis considerations have their greatest force. Congress has never overturned this court's interpretation of Title VI. Petitioners aren't asking this court to revisit its interpretation of Title VI.
On the text, though, do you have anything else?
I would point to the ambiguity in the term discrimination.
Okay. But it's not ambiguous in Title VII.
No, and we respect this court's decision in Bostock.
It's just ambiguous in Title VI, the same word.
This court has held that multiple times.
Okay. What do we say to Asian Americans who there's a veritable cottage industry, we're told by the briefs, that they are encouraging Asian applicants to avoid and beat, quote, Asian quotas? That's how they perceive it. Is that an important consideration? And that they tell applicants, coaches tell applicants to disguise their backgrounds and their names to the extent possible in order to secure what they view as an even footing in the admissions process?
I find those accounts appalling. They are not permitted under the Constitution. It's very clear that racial identity cannot be treated as a negative. That would be intentional discrimination. It's prohibited under equal protection. It's prohibited under Title VI, and Grutter does not countenance it. So to the extent that that is happening at any educational institution around this country, it's unlawful, and the university should be held accountable for it.
Thank you.
Justice Kavanaugh?
I understand your point about the race-conscious decision-making being allowed in certain circumstances under the Equal Protection Clause. Certainly precedent in the school desegregation cases allows that as well, and so does Bakke, obviously. And you read Justice Marshall's opinion in Bakke, and that's a very forceful and compelling explanation of why that is so important and why that was, in his view, necessary for some time. But even in Bakke, Justice Blackmun was saying there must be a time limit. He said, I hope 10 years. This was in 1978. And he then said, that hope is a slim one. And then you got to Grutter. And that was a very similar argument to this one. And we've talked about, just pick up on the Chief Justice's question, the reference there, I think, was because Justice O'Connor's majority opinion was concerned about indefinite extension. And you've said, don't worry about that. How will we know when the time has come?
The time will be here when universities are able to enroll diverse student bodies without having to take explicit account of race in the admissions process.
If I can just break that down, I think what you're saying, but correct me if you disagree, is that when race-neutral alternatives produce a sufficient percentage of underrepresented minority students in the student body. Is that an accurate translation?
Yes, when it allows for meaningful representation and meaningful diversity on those campuses.
Okay, and what, I use the word sufficient, use meaningful, but what number?
So I think that it's not reducible to a precise number or percentage. The court has made clear, and just recently in Fisher 2 considered exactly this question and made clear that, of course, there aren't quotas or specific numerical thresholds that need to be reached. That's not the right way to think about the diversity interest in this context. Now, I don't want to suggest that demographics are wholly irrelevant here. The court has also said in Grutter and then reiterated in Fisher that numbers can remain relevant for purposes of trying to measure whether there's truly a meaningful opportunity, for example, to have cross-racial interactions.
But if you don't have a number, and I understand why it's difficult, and I understand the problems with that, I get all that, but if you don't have something measurable, it's going to be very hard for this court if we're called upon 10 years from now or 20 years from now. It's going to be, this is a bit of a replay of the Grutter argument, but if we come back to it, okay, are we there yet? What do we look at? You're saying meaningful opportunity. I don't know exactly what that means. I don't know how the schools will know when they have to, when they've, when the race-neutral alternative could get them close enough, or it has to meet some threshold. I don't know what meaningful means. I know what it means in terms of what you're describing. I don't know how it translates to looking at the composition of a student body achieved through race-neutral alternatives and says, yes, that gives them meaningful opportunity. And I don't know how educators are going to make that decision, so any help you can provide on that, I would appreciate.
Sure, and I think that it's going to be tied to the direct educational benefits that the university has articulated that it's trying to achieve, and those can be measured. I would point to, I think, 3 overarching categories or ways to try to measure progress toward the goal. The first can be quantitative or objective evidence. I'll use the service academies again as another example. One of the things they have looked at and measured is the disparities in graduation and attrition rates. And the Coast Guard Academy, for example, discovered when it went to Congress in the early 2000s to try to ask Congress to lift the ban on the use of race in admissions, which Congress did in 2010, what the Coast Guard Academy said is it had studied the issue with respect to women and discovered that when enrollment of women stabilized at about 25 to 30% of the population, those disparities of women not graduating at the same rate as men fell by the wayside and disappeared. And so I think graduation and attrition rates are relevant. I think that a university can also measure the degree of race-related incidents on campus and whether those are happening. I think the university can look at patterns of enrollment in its classes to determine whether the classroom environment is diverse and there are those opportunities for cross-racial understanding. So that's all the first category. The second category I would point to is the one I've already referenced, demographics. I think that that can be relevant, again, not to set a quota, not to identify a precise numerical threshold, but in recognition that when there are extreme disparities in representation of certain groups, it can cause people to wonder whether the path to leadership is open. And if I could, maybe I could just give a common sense example of that I would hope would resonate with this court. The court is going to hear from 27 advocates in this sitting of the oral argument calendar, and 2 are women, even though women today are 50% or more of law school graduates. And I think it would be reasonable for a woman to look at that and wonder, is that a path that's open to me, to be a Supreme Court advocate? Are private clients willing to hire women to argue their Supreme Court cases? When there is that kind of gross disparity in representation, it can matter, and it's common sense. And then the third category, to finish this up here, that I think that universities can look at is subjective or qualitative evaluation of actual student experiences. You can do things like conduct high-quality surveys of students to ask them, what opportunities have you had to interact with people of a different race from you? What did you learn from those experiences? Did it challenge your thinking? If you are an underrepresented minority student, do you feel isolated? Do you feel like you have to be a spokesperson for your race? And so that can yield relevant data as well to help measure progress toward these goals.
Thank you.
Justice Barrett?
General, I have a question about the originalist evidence. And, there's nuance in that, and I don't want to get into the details of that. But my question is how it would affect your position in this case. So I entirely agree with you, and it's established in our precedent that it's not always illegal to take race-conscious measures. Remedial measures, are an example of that. Do you agree, though, on your understanding of the originalist evidence that strict scrutiny, and obviously we didn't think about scrutiny in those days, but it's not accurate to say, I agree with you, when you look at the originalist evidence, that it was always colorblind, that some race-conscious measures were permitted, at least in a remedial sense, right? And desegregation is an example of that. So the question is, under what circumstances have those remedial measures been permitted? And, that's a Section 5 question. How would that originalist evidence affect your case? If you were writing on a blank slate, would you say that university affirmative action programs don't implicate the 14th Amendment? Or are you saying that they just very plainly would satisfy our modern tiers of scrutiny because the interest is compelling, even if we didn't have Bakke, Grutter, Fisher, et cetera?
I think that because they involve racial classifications, it is necessary to test them under strict scrutiny. And so we're not suggesting that under an originalist case, they would just be automatically exempt. I think the court has rightly recognized in this context that any time a racial classification is used, you want to subject that to the most searching scrutiny in order to test for whether it could possibly be justified based on compelling interest, and also, of course, to push on narrow tailoring. But here we think that the court rightly concluded in Bakke and Grutter and Fisher that narrow tailoring and compelling interest are satisfied. Thanks.
Justice Jackson?
Yes, I just wanted 2 quick things. One is about the originalist position. Isn't it at least ambiguous as to what the history is telling us about whether or not race consciousness can be used I know your position and the position of some folks is that it's clear that the history is saying race consciousness is okay. And as Justice Barrett mentioned, there is evidence of that. And if there's evidence on the other side, don't we need to have a clear picture of this in order to overcome stare decisis? I mean, we have the historian's brief that says even if the history was unclear, and it's not, overcoming stare decisis requires something more than ambiguous historical evidence. Do you agree with that?
I do agree with that. I think the petitioner bears a heavy burden in this case because we're in a situation where stare decisis considerations apply, and I think it would be destabilizing for the court to turn its back on precedent here. And I think what can undoubtedly be said about history, although there are some complications in the record, what is undoubtedly true is that petitioner has not been able to point to any clear history to support the notion that racial classifications were automatically and invariably unconstitutional.
And finally, is there some connection between how race is being used and the concerns that some of my colleagues have about the amount of time? So what I'm trying to get at or think about is whether Bakke, for example, Bakke was a set-aside program as far as I understood, that there was actually 16 seats in a class of 100 that were being set aside for underrepresented minorities, and therefore, obviously, the concerns about perniciousness and being problematic, and we want it to end. We don't want this going on forever. But when you have a situation like this, in which you're talking about a holistic review, other people are getting pluses in the system, no one's automatically getting a plus in the system, I wonder if the urge to end it, and what is the end it? The end it is to include race alongside 40 other characteristics. I wonder if it implicates the same kinds of concerns about the use of race.
Yes, Justice Jackson, I think that there is a lot of force to that point, and I think that the UNC record really illustrates this point, that UNC has held itself to the standards this court has articulated in using race as only one of a multitude of factors in holistic admissions, in deploying race-neutral alternatives, and not using race when it's not necessary to achieve true student body diversity. And maybe that means that given the limited way that race functions, it is taking longer for our society to get to the point that everyone agrees we will eventually reach, but I don't think that that's a basis to condemn Grutter now and halt progress in its tracks.
Thank you.
Thank you, General. Mr. Strawbridge, rebuttal.
Thank you, Mr. Chief Justice. I'm going to try to make 4 points here. First, with respect to the military, the United States brief on that is long on assertions that race-neutral alternatives are not available to it and would not work, but not actually long on any evidence of that fact. We don't know precisely what race-neutral alternatives they have looked at. We don't know what has been tried. We don't know what else could be available to them, especially with the fact that they can draw on appointments from the enlisted ranks, as well as from prep schools. The only actual information we have about how race-neutral alternatives might work in the military academy setting is the Coast Guard, when it was race neutral. The last year that the Coast Guard was not using race as a factor in admissions, it expanded race neutral recruiting and other pipeline initiatives, and it obtained underrepresented minority enrollment within 2 points of the Air Force Academy and West Point, which were using race as an admissions factor. Nor is there any evidence to suggest that the ROTC candidates who come from Texas and A&M and Florida and California and Michigan are less diverse, let alone have received fewer benefits of educational diversity than those who come from UNC. With respect to the originalism point, obviously we think that our reading is consistent with the originalist reading. The best source on this is actually the United States brief in the Brown re-argument hearing. It has actually the most complete survey of information about the meaning of the 14th Amendment, and it concludes on page 65 of that brief that a general understanding of the broad scope of the 14th Amendment when it was enacted is that it would, quote, prohibit legal distinctions based on race or color. That is our position. That was the position in Brown. It's the position that prevailed today. There is an assertion that California and Michigan have seen their white enrollment go up since they discarded the use of race. That is not true. In Michigan, underrepresented minority is actually higher today than it was during race-conscious admissions. Additionally, Asian American admissions have gone up 6 points. Asian Americans are not white. It's necessary that the white share of the class has gone down. At California, the most recent, or the 2021 class at California, and there was testimony about this in the trial record, Berkeley is 19% white, it's 15% Mexican American, it's 5% other Hispanic, it's 16% Chinese American, it's 4% Vietnamese, it's 4% Korean, and it's 4% black. And we are told that the students there are somehow being deprived the educational benefits of diversity or are being deprived a diverse environment. I don't think that's correct. Finally, with respect to my friend from UNC, he insisted that they were committed as close as they could to exploring race-neutral alternatives and having an endpoint. There was no criteria described to this court by which one could ever conclude that their interest in obtaining educational benefits had been satisfied. There was a reference to climate surveys, but the director of admissions testified at trial that he had not looked at a climate survey in 10 years. There was no plan ever to consider sunsetting their use of race. There was never even a serious effort in the office to measure what the effect of race was in their current admissions program, even though they had done so for gender, for legacy status, and for time of application. I don't think that's consistent with a university that's actually committed to moving off of race. The fact that the district court found this all survived strict scrutiny under Grutter is a reason to overrule Grutter.
Thank you, counsel. Counsel, the case is submitted. We will take a 10-minute recess.
at all.
So today, a benefit to descendants of slaves would not be race-based, correct?
I think that's incorrect, Justice Kavanaugh.
Well, how does that, you just said benefit to former slaves was not race-based in the Freedmen's Bureau. How is that different now?
Well, the remedial exception that this court has recognized is fairly narrow. It has to be prior.
The question's whether it's race-based.
Right, okay.
You said, I think, to Justice Gorsuch, I'm sorry to interrupt his question, but you said to Justice Gorsuch, I think, that the benefit for former slaves was not race-based. That's correct. Then the benefit for descendants of former slaves is also not race-based. You can make other arguments if you want about that, but it does not seem to be race-based under what you said to Justice Gorsuch, correct?
Not correct. I think there's a difference between the former slaves themselves getting a benefit versus generations later. I think that's a classification on the basis of ancestry, which is still problematic under this court's precedents. Even if it's not directly race-based, I would assume that universities are, and it would depend on the record, but universities are drawing that classification as a proxy for race in ways that the Reconstruction Congress was not.
Okay, if I might just finish up. The Freedmen's Bureau is on the federal side. We have some briefs before us that also talk about practice on the state side. Now, we know that shortly after the Civil War, there were a lot of race-based statutes passed by states, and most of them were Jim Crow laws that invidiously discriminated on the basis of race. But your friend on the other side cites two that he says are not, one from Kentucky and one from South Carolina. Could you address those?
Yes, so we cite a book full of statutes from the same era from states that were purely colorblind. But they do cite two examples, one from South Carolina, which I believe banned racial discrimination by government licensed entities. And there was a finding by that legislature that our government licensed entities were continuing to discriminate on the basis of race. I think it was a remedial measure. It made sense in light of the end of the war and the massive racial discrimination that was still ongoing. Now, the Kentucky statute is even clearer. It gave benefits, it was a racial classification, but it gave benefits to a group of people in Mercer County, Kentucky, who had no property, were so injured they could no longer work, had no income. I think that what the statute was talking about were the people, the recently freed slaves in Mercer County, to which there were many.
And then I have one final question about this. There's also a question of whether we should pay attention to state practices, given the language of the 14th Amendment, which doesn't pertain to, or whether we should pay attention to the federal side, given that the language of the 14th Amendment doesn't purport to bar remedial measures or classifications by Congress, which at that time was in full Reconstruction efforts, but that the drafters of the 14th Amendment were especially concerned about racial classifications at the state level because so many of them, everyone knew, would be used as Jim Crow laws were to discriminate against African Americans.
I think there's something to that, Justice Gorsuch. Justice Scalia recounted some of that history, I think in Croson and maybe Adirond, where he said there's no reason to think that the same distrust of the federal government would have been there at the time. But I don't think any of these federal statutes are even particularly hard if you assume the equal protection principle binds the federal government, because they are all plainly remedial. None have anything to do with diversity, and Harvard has not pressed the remedial interest that justified those statutes.
I'm sorry, but many of the civil rights statutes and some of the laws pertaining thereto were directed to being equal to whites. So there was consciousness of race in those statutes.
I think not in a relevant sense. Those statutes, this court said in the Jam case in 2019 that exact language is colorblind, that whites, you have to have the same rights as whites, which means everyone is equal. Now, they used race-based language, but what they did was they banned racial discrimination.
So
That's
what
not
do
race
we
consciousness.
do about all the legislation that was passed that gave benefits not just to former slaves, but to free blacks? That was still remedial in your mind? Because there was inequality, correct?
I believe it was. And it was in response to an entire system that had been built up of de jure discrimination. I think those were remedial statutes as well. And
so even if we have de jure discrimination now or segregation now, Congress can't look at that? Because we certainly have de jure segregation. The races are treated very differently in our society in terms of their access to opportunity.
I believe that the remedial exception is still good law. It was one of the two things that justifies the use of race in education that this court identified in parents involved. However, Harvard has not made that argument, has no factual record that you would need to support that argument. It does not justify its use of race based on its own prior discrimination against blacks and Hispanics.
Are you aware of de jure segregation today?
I am not. I am aware that that racial preferences on college campuses, in our view, have increased racial consciousness, and so there's some of this is happening on campus, but it's not de jure.
It's not clear that there's segregation between their large swaths of the country with residential segregation. There are large numbers of schools in our country that have people of just one race. There are schools, districts that have only kids of one race and not multiple race or not white people. De jure to me means places are segregated. The causes may be different, but places are segregated in our country.
Absolutely. And I think the top 10% program in Fisher, which really got a bad rap in Fisher too, but was solutions like that are meant to account for residential segregation in a race-neutral way.
Yeah, the problem is that they don't. That's what the district court found.
My memory of Fisher 2 was that the top 10% program was extremely successful at increasing the enrollment of underrepresented minorities at Texas. There are other solutions. We have a very sophisticated race-neutral alternative in this case that takes into account socioeconomic status and forces Harvard to eliminate its preferences for the largely white legacies. And that is another way. I mean, our numbers, the number of Asians would increase on campus, the number of Hispanics would increase on campus, the overall number of underrepresented minorities would increase on campus.
Blacks wouldn't increase.
Black representation would be 10%, which is higher than it is in the state of Massachusetts, and that number is quite low. Our expert testified that if Harvard was only willing to consider wealth instead of income, that number would be quite a bit better, because the main disparities we see on the basis of race today is not on parental income, but on generational wealth.
Harvard argues, though, that we have a compelling interest in diversity writ large, and that this court has deferred to that interest. And among the diverse things that we need to have in our class are children of large donors. There's evidence about that museum we talked about earlier, children of legacies, and squash team. I'm not making it up. It's in the record. And to what extent should this court be deferring to those interests as part of its compelling interest analysis?
Not at all, Your Honor. I think strict scrutiny means you need to be able to reject race-neutral alternatives because they don't satisfy the compelling interest, and the compelling interest is overall broad-based diversity, not declines in our fencing status, not drops in 5 points on the U.S. News and World Report, but it's diversity. And Harvard, it's a little ironic in this case, Harvard is not diverse at all. Besides its racial statistics, 9% of incoming freshmen at Harvard are conservatives. Harvard is 82% wealthy. There's 23 rich students for every one low-income student on campus. It is not diverse in hardly any other way. And so I think that the compelling interest that you recognized in Grutter is not what's actually being pursued on Harvard's.
You heard the...
Go ahead. I mean, are you saying now that there is an interest and a compelling interest in racial diversity among other kinds of diversity? I mean, putting Harvard's, whether Harvard should be more socioeconomically diverse, probably should be. But putting that, I mean, is there an interest in racial diversity?
I agree with my colleague, not a compelling interest that could justify a racial classification. But racial diversity is not a bad thing. It is a great thing. It is something.
But the whole premise of this, right, and, we can talk about whether these programs are narrowly tailored, whether the universities have done enough to, with the use of race-neutral criteria. But the premise of your argument is that even if race-neutral criteria could not achieve the object, Harvard can't use race-conscious criteria. And that must be because you think it's just not important enough. Isn't that right?
I don't think that's right. So we have very detailed record evidence here that if Harvard just turned off race on its admissions process, it would still have 6% African Americans, I believe it's 9% Hispanics, so 15% underrepresented.
So you think good enough, but how about if it were 2%? I mean, the nature of your argument is that it doesn't matter. That's what the nature of your argument is.
I disagree, Justice Kagan. It does matter because if you're below those numbers, then Harvard's probably discriminating in some sense, and it should stop. Or it's not reaching underrepresented minorities in the way that it should. Perhaps it should not.
Well, that's just fighting the question. I mean, the question is, is there a limit beyond which you would say, oh, yes, if you can't achieve that level of diversity with race-neutral criteria, then you're allowed to use race-conscious criteria?
I don't think there's any level that justifies explicit racial classifications, but I'm going to fight the hypothetical one more time if you'll let me, because
Yeah,
race-neutral
no, I don't
alternatives.
think I will. So let me just go on and ask you a couple of other things. I mean, because this is, to me, this is a lot of the argument here is about a university has a compelling interest in collecting a diverse class, including along racial dimensions, and maybe especially along racial dimensions, given the kinds of challenges that our society faces, in the exact same way that all the other institutions of our society does. So I'm just going to ask you some questions about that. If you're a hospital and you serve a diverse group of patients, is it super important to you to have a diverse set of doctors?
I don't know that the evidence about the diversity of doctors and patients or anything about the medical field.
It wouldn't matter, yeah. Okay, or maybe it would, you don't know. If you're a police department and you serve a diverse community, is it super important to you to have a diverse set of police officers?
I mean, I believe that's important if there's good evidence that a racial classification was needed. That has nothing to do with the educational benefits of diversity in universities. That's the interest that Grutter
Do you
upheld.
think that if you're a law firm, or if you're a judge and you want to have a diverse set of clerks, do you think a judge can't think about that in making clerkship decisions?
Absolutely can think about it. This court's decision in Feeney says knowledge of race is not the violation. It is using it as a factor to distinguish them.
Let's say a judge says, I want a diverse set of clerks. That's, I want clerks who would, grade on any number of criteria, but I also want a diverse set of clerks. So over the years, people will look at that and they'll say, there are Asian Americans there are Hispanics there are African Americans there, as well as there are whites there. Can a judge not do that?
I mean, I think that is a admirable goal. I don't think a judge could implement that goal by putting a thumb on the scale against Asian applicants or giving a big preference to Black and Hispanic applicants. I think you need to treat people equally based on race, just as you're not going to hold my race against me in judging the quality of my arguments. I think racial diversity is important because it's a good metric to make sure our institutions are equally open. You can certainly be concerned about that. But the question is using racial classification, telling people that you didn't get the clerkship because of your race.
Yeah, but the point here is, look, everybody would rather achieve all our racial diversity goals through race-neutral means. Everybody would rather that. And that's certainly what our cases say you have to do. The question is, when the race-neutral means don't get you there, are you prevented from taking race into account in all those ways that I said? And I could add a dozen more. Businesses who find it necessary, in order to achieve their economic objectives, to have racially diverse workforces. I mean, I could go on and on and on. And the question is, when race-neutral means can't get you there, don't get you there, when you've tried and they still won't get you there, can you go race-conscious?
I don't believe so, Justice Kagan, and I think this court has already said in Parents Involved that racial diversity is not a compelling interest. It is overall diversity of all kinds on college campuses. And this doesn't have to be hypothetical. We presented an alternative to Harvard that would achieve socioeconomic diversity for the first time, that would boost underrepresented minority representation, that would lower the number of white students on campus. And so we're talking not about no diversity and diversity, we're talking about 10% Black representation or 14% Black representation.
That's your, I would say, narrower argument. I think Justice Kagan's right that you have a broader argument that it wouldn't matter. Then you have a narrower argument, as I read the submission and hear you, that even under the Bakke-Grutter framework, race-neutral alternatives suffice to achieve the kind of sufficient diversity. And I'm going to ask you the same question I asked the Solicitor General, which is, how do you measure that on your narrow, or as I see it, argument? Maybe you don't want to accept my characterization, but on what I see as your narrower argument, what is sufficient? What's meaningful, to use the Solicitor General's words, in your view?
Well, I think you need to be measuring, I mean, if you just take Rudder's interest as a given, you need to be measuring whether your student body is diverse on all dimensions. I don't think Harvard is
Now,
there.
let me ask it specifically. How do you know whether a race-neutral alternative proposed would be sufficient, adequate to achieve sufficient levels of otherwise underrepresented minorities that you would satisfy what Bakke and Grutter, which I know you disagree with, but would satisfy what those achieve? And you heard the Solicitor General's answer, and I'd be curious your responses to her or your alternative submission on that.
Well, I think the burden is on Harvard, and so Harvard would need to come forward with evidence about race-neutral alternatives that have been presented or that it's considered itself, and show how under that alternative it's not getting the educational benefits of diversity. Now, in this case, Harvard, the only testimony we have is that Harvard doesn't know what number it needs to get the educational benefits of diversity, doesn't know what evidence to consult to know whether it has that, doesn't know what the evidence would even look like, as Dean Fitzsimmons testified, and the only evidence is Harvard's report on the importance of diversity.
But in looking, I'm sorry, looking at your proposals or looking at California or Michigan or Washington, one of the big themes, I think, of the brief is, hey, we have these states that have done race-neutral alternatives, and that's been effective in achieving diversity. I think you can dispute that characterization, but that's a theme I gleaned from the briefs. And as I look at that, I want to know, well, what does that mean, effective or adequate? What's the measurement? Really the same question I had for the Solicitor General. It's asking us to say, yes, that's adequate, but what does that, got to say more than that, I think.
Part of the problem, I think, is the fuzziness of the interest in Grutter itself. But
No. Accept the interest.
Okay.
Sorry to interrupt. Accepting that the interest, race neutral, this is the back part of your brief, race neutral alternatives are adequate. And I just want to know, okay, well, California, Florida, great. That's adequate because, and that could be translated to Harvard because.
the University of California system is the most racially diverse elite institution in the world. Whites are the third most represented group on campus. So if racial diversity has these educational benefits and they've achieved them, I think they study their undergraduates on your racial consciousness and your cross-racial understanding. They get really high scores at Berkeley. Berkeley and all the UC system tells prospective students that we have a very diverse student body and that the educational benefits that you would expect to get from that are present. It's the top-ranked public university in the country. It's
your
great.
point then, the necessary add-on point is, and that could be translated to Harvard in essence, or something sufficient could be translated to Harvard, and I just want you to fill in the blank there. Why?
I think you can. Our race-neutral alternative that we've focused on, Simulation D is what we called it, would make Harvard they would go from 82% economically advantaged to 51%. You would actually have pure socioeconomic diversity where it's about 50-50. The number of white students would decrease, the number of Asian students would increase, the number of Hispanic students would increase. I think you'd see lots of benefits in that.
The number of black students would decrease from what to what?
Would decrease from 14% to 10% was the number. And our expert testified that that number, 10% is an absolute floor because the number couldn't be higher because his socioeconomic preference didn't have the sophisticated data that Harvard has. I think that's successful on any metric. And I've never heard Harvard prove the delta there as being necessary for educational benefits of diversity.
Counsel, I don't know what to do in a situation like this one. If you have perfect scores on every metric, you're not guaranteed a spot at Harvard because they have enough people with perfect scores of every background that exceeds their class limit. At some point, something has to break the tie. And as we know, top 10% students of Asian and of Black and Hispanic backgrounds in academic and extracurricular activities are not being admitted to Harvard. So it's not as if once we say, take race out of this, that all of the people that you consider super qualified are going to get in. But on every matrix, there's going to be competing applicants. And you're saying a school can't look at its general diversity figures and say, among equal applicants, I might make race a tiebreaker if the numbers that I have on that metrics seem fairly low. Otherwise, you're saying, no, you can't do that.
No, you cannot do that. That's what Title VI forbids. It doesn't
And
forbid
that
it.
basically, what you're saying is really race diversity is not important. So I don't actually see why all the race-based, because all of the alternatives, whether it's the 10% plan, whether it's socioeconomic, they're all subterfuges to reaching some sort of diversity in race. You're touting them as race neutral, but none of them are race neutral. You're doing them because you believe in racial diversity. I just don't understand why considering race as one factor, but not the sole factor, is any different than using any of those other matrix.
Well, I don't think those are racial classifications in disguise. Harvard's never criticized Simulation D that we presented as a racial classification in disguise. It criticizes it because it doesn't hit Harvard's precise racial numbers. It's based on socioeconomic status, and I don't think anyone thinks eliminating legacy.
It reduces SAT scores, averages, it reduces lots of other factors to get to your numbers.
I mean, I think that's our point, that SAT scores would go from the 99th percentile to the 98th percentile. That's not sacrificing academic excellence. That's moving Harvard from Harvard to Dartmouth. Dartmouth is still a great school. That they get 98th percentile SAT scores. You've got to make some sacrifices.
There are those who love it.
Thank you, Counsel. Justice Thomas. Justice Alito? Anything further? Justice Kagan?
One question about how to think about the 25-year sentence in Grutter and the surrounding discussion.
Yeah, absolutely. I think that what people forget about the 25-year mark were the 4 paragraphs you mentioned before it, where they explain that racial preferences, they will fail their own acid test unless they make themselves unnecessary. So I think what Justice O'Connor was saying is that in 25 years, if we still need race, it's not that you get another 25 years, it's that we then declare racial preferences to be a failure and call it off and go to race neutrality and try that instead.
Justice Barrett?
But we're not to that 25-year point yet, right? So if it has its own self-destruct mechanism where it says, like, hey, Grutter says we got to call it quits because they're just not working, are we obligated to give more time?
Well, Harvard has certainly never indicated that in 5 years it will stop using race. Harvard, over the 20-year span, has not decreased its use of race at all. And I think the only legal standard this court has ever recognized for when do you stop using race in education is in Brown, with all deliberate speed. The 25-year mark, we don't support it from the get-go. But we do think there was a prediction from Justice O'Connor that is not borne out. And so Grutter, on its own terms, I think 20 years is enough to call it.
Thank you, counsel. Mr. Waxman?
Mr. Chief Justice, and may it please the court, the evidence and findings in this case confirm what this court has long recognized, that a university student body comprising a multiplicity of backgrounds, experiences, and interests vitally benefits our nation. Stereotypes are broken down, prejudice is reduced, and critical thinking and problem-solving skills are improved. Student body diversity makes our businesses more innovative and globally competitive, our scientists more creative, our medical professionals more effective, and our military more cohesive. Experience has more than borne out Justice Powell's observation that our future as a country depends on having leaders who have enjoyed wide exposure to students as diverse as the nation itself. And so, as this court has consistently held, if necessary to achieve genuine diversity, a university need not blind itself to race, which, like the type of high school an applicant attended, their socioeconomic and family background, or the part of the country they live in, forms a part of who they are. Now, SFFA attempts to use Harvard's admissions program as some sort of proof that settled constitutional precedent is egregiously wrong. But while SFFA is fully entitled to its own legal arguments, it is not entitled to its own facts. Following exhaustive discovery in this case, the trial court considered the testimony of 30 witnesses and detailed expert analysis and made extensive, meticulous findings which the Court of Appeal robustly affirmed. And those findings, applying strict scrutiny, are that Harvard does not improperly emphasize race in its admissions decisions. It does not engage in racial balancing. It most certainly does not discriminate against Asian American applicants, and it does not yet have a current workable race-neutral alternative. The false narrative to which SFFA clings is no basis to dismantle decades of precedent confirming the constitutionality of limited race consciousness in admissions. And I very much welcome the court's questions.
Mr. Waxman, the petitioner argues that over 80%, that actually you do have available a race-neutral approach that would yield different but excellent results. And the argument includes the fact that, at least as they argue, that you're over 80% wealthy students, that's not diverse, and that over 30% or 30% or so of a class is made up of ALDC students. And that if you were to lower those numbers, you could achieve far more diverse results without along socioeconomic lines. And I don't think it's arguable that Harvard is socioeconomically diverse, but at least it doesn't appear that way. But it seems that, and that would not have a constitutional problem if you did it socioeconomically. And I'd like you simply to address their argument.
Yes, thank you. First of all, the numbers that my friend is throwing around are not, in fact, the numbers that actually reflect, for example, socioeconomic diversity at Harvard, where, as it stands now, 20% of all matriculants pay nothing, 70% of underrepresented minorities pay nothing, and well over half of all applicants get substantial financial aid. But as to your point about race-neutral alternatives, and correct me if I'm wrong, Justice Thomas, but I think this is what you're asking me about. We have exquisitely detailed metrics in this case with respect to race-neutral alternatives and findings and testimony with respect to the so-called ALDCs, which is an acronym that I think I was actually literally present at the birth of, which is a preference for children of alumni, children of faculty and staff, athletes, and other people who have found themselves on the dean's interest list. The data in this case shows that if race were eliminated, you couldn't consider race, and you also could give none of those preferences, the racial diversity of the matriculating class would go down. The representation of African Americans, if you just stop considering race, would go from 14 to 6%. But if you also stop considering ALDCs, it would go to 5%. With respect to—
Let's just say hypothetically, though. Hypothetically. And I know I'm going to get—
I know all the usual caveats, and I accept them.
Thank you, Mr.
Yes,
Waxman.
I'm pretty sure since you're asking me, I'm not going to like—
You're not going to like it. But let's assume that a very wealthy university could pay for everybody to go and still increase its endowment. It's a perpetual motion machine, Malcolm Gladwell called them. Let's say if it just gave up preferences for donors' children, legacies, and squash athletes, okay? Or maybe those who row crew, all of which tend to favor predominantly white children. And it could achieve whatever it deemed racial diversity. Would it then be permitted to engage in race consciousness, or in that circumstance, would you agree that that would not be narrowly tailored?
So I'm not claiming, I'm accepting your hypothetical as hard as it is for me in light of what the evidence shows.
There we go.
I am not claiming that there is a compelling interest in having donors per se. There is a compelling interest in your proverbial art museum. There is a compelling
interest in the art museum?
No. These are the things that I'm not claiming. Okay, I'm just
sorry.
claiming all of those things.
All right.
When you look at a so-called race-neutral alternative, the question that this court, that Justice Powell articulated in Bakke and this court underscored and amplified in Grutter and then in Fisher is does that race-neutral alternative actually substantially impact the character of the institution and the education that's being provided?
Now, let me stop you there, because, and I'm sorry to interrupt, but surely getting rid of those preferences would substantially impact the university. But you're saying they are not a compelling interest for constitutional purposes.
So no, what I'm saying,
or does the 14th Amendment make legacy children?
Of course.
Okay, no. So we agree.
Of course not. And the truth of the matter is that if this were a case in which the evidence showed that eliminating a legacy preference made a substantial difference, the district judge to say that the district judge was applying strict skeptical scrutiny on the narrow tailoring principles is quite an understatement.
Okay.
Might have decided otherwise. What the district court found, and Judge Gorsuch, if I can just make one comment about the record, which I think responds to at least the gist and spirit of your hypothetical. With respect to race-neutral alternatives, the simulation, what has come to be called Simulation D in this court, the district court found that, quote, the Simulation D would require, quote, sacrifices on almost every dimension important to Harvard's admissions process. Among other things, and these are all recited in the Smith Committee report, they are recited in the extensive discussion of race-neutral alternatives in both the district court opinion and the Court of Appeals opinion, are that, for example, with respect to academic excellence, the academic factor, the number of matriculants who score 1 or 2 on the 5-point scale would go down 17%.
I'm familiar, Mr. Waxman, I'm familiar with all of that along
in other
with,
words,
we go down from 99 to 98th percentile. I've got it. If I might shift gears, okay, I'm familiar with all those, and I appreciate that, and I understand your point. It was a hypothetical. What do we do about history here? Because one thing we know, or we think we know, or we're told in the briefs at least, is that Harvard's move to a holistic application approach happened in the 1920s because it wanted to impose a quota on Jewish applicants, but it didn't want to do through front door. So it used diversity as a subterfuge for racial quotas.
What the record in this case shows, and it's discussed in some detail in the, I'm going to blank on the names of the reports, but the various reports that Harvard has done over the years on diversity and diverse admissions in the case. One is the so-called Rudenstein report, and the other is the Khorana report, both of which are in the joint appendix, is that Harvard actually, even before the Civil War, has at its admissions policy an effort to, in fact, diversify on both viewpoint and geography the class. Now, there's no doubt, and Harvard acknowledges and is ashamed that in 1920, one of its presidents, President Lowell, decided that there were too many Jews and that they were then going to start asking questions on the application that would allow them to take into effect character. The notion that that bears at all on the way that Harvard's current admissions process, which uses a 40-person admissions committee that meets and decides each application en banc in discussion, has any resemblance whatsoever to the racist, anti-Semitic policy of a single Harvard president is insubstantial, as the courts found.
Okay, how do you respond then to again, we have many briefs on this point from Asian American applicants who have, and they say there's an entire industry to help them appear less Asian on their college applications, and that they consider elite colleges to have Asian quotas effectively, if not in name.
I'll say two things. One, generally about the amicus briefs, and two, specifically about Harvard. And I certainly want to get to number two. But there are multiple amicus briefs filed by Asian American organizations, and one that is particularly, I think, powerful, filed by 1,240 scholars of Asian American experience and Asian ethnicity, all of whom not only opine, but cite studies showing that Asian Americans as a group, and Asia, of course, represents 61% of the world's population and a multiplicity of ethnicities, that Asian Americans demonstrably benefit from a holistic admissions policy that considers race as one factor among many. Now, with respect to Harvard, to say that there was evidence in this case is quite an understatement. The district court found, I'm quoting page 261 of the joint appendix, and it's reiterated by the Court of Appeals on page 80 of the joint appendix, that there was, quote, no evidence of discrimination against Asian Americans whatsoever. Again, now on page 264, there was consistent, unambiguous, and convincing testimony that there was no discrimination in the admissions process in general and the personal rating in particular. The plaintiffs in this case could not, after 4 years of discovery in which they hand-picked applications to view in total, they could not produce a single witness to testify that he or she had been discriminated against.
Mr. Waxman, let me stop you there because you referred to the personal score. And that's a score that Harvard gives based on character traits such as integrity, courage, kindness, and empathy. But the record shows that Asian student applicants get the lowest personal scores of any other group. What accounts for that? It has to be one of two things. It has to be that they really do lack integrity, courage, kindness, and empathy to the same degree as students of other races, or there has to be something wrong with his personal score.
I want to get to what the evidence was there, but that syllogism, with all due respect, is wrong. There was, for example, a study that was done in 1983 that looked at why it was that female applicants to graduate school at the University of...
No, just address this. The personal score that's given to Asian applicants to Harvard, why are they given a lower score than any other group?
Okay, so the answer to why they, as a group, why there is a slight numerical disparity with respect to the personal rating of Asian Americans, and also a slight numerical disparity to the advantage of Asian Americans with respect to the extracurricular rating and the academic rating, was the answer that their expert gave with respect to the latter two, which is that the only way that the only model that can be created to figure out what was going into the personal rating couldn't look at almost anything that admissions officers look at in those ratings. It can't, there's no way that it could model what the guidance counselor letters said, what the teacher letters said, what the essays said, what the interviewers' letters said. In other words,
I thought the interviewers did not rate the applicants lower than other applicants based on race. There was not the disparity in what was said by the interviewers.
With respect to the alumni interviewers, based on the subset that was included here, their subset, by the way, excluded all ALDC applicants. That is, even though they acknowledged that there was not only no evidence of discrimination against Asian American ALDCs, but they did better, they eliminated from their model applicants that represent, on average, 30% of the admitted class.
I still, putting aside the teacher recommendations or guidance counselor recommendations, which I'll come to, I still haven't heard any explanation for the disparity between the personal scores that are given to Asians. They rank below whites, they rank way below Hispanics and really way below African Americans. And you're talking about hundreds and hundreds of applicants, maybe thousands. What is the explanation for that?
So the explanation that was, I can't do better than the findings of fact in the trial court as affirmed, but I want to make 2 points very clear with respect to your question. All of this was on display and in front of the trial court for this Asian American part of it for well more than a week, maybe 2 weeks. The district court found, considering all of the evidence, that there is, quote, no credible evidence that corroborates the improper discrimination suggested by SFFA's interpretation of the personal rating, page 264.
Well, all right, I'll try one more time. The district court found, quote, a statistically significant and negative relationship between Asian American identity and the personal rating assigned by Harvard admissions officers.
That's correct. And what she said is the record will not allow a full explanation of that because there was no evidence with respect to what teachers said, what guidance counselors said, what these students wrote about. But what we can say with respect to the allegation of discrimination in this case, which was the definition of discrimination that was at issue in Bakke and Grutter and Fisher, and which their lawyer got up at opening statement and said, when we talk about discrimination, in this case, we're talking about discrimination in admissions outcomes. And here again, the district court found, and the Court of Appeals also concluded, that there was no evidence of discrimination in admissions outcomes against Asian Americans, whatever you think about the personal rating, which is, after all, simply a number
Justice Alito would like to ask a question.
I'm sorry, I'm not trying to filibuster you.
Finish your sentence, then
Okay.
I will ask one more question.
I want to make one other thing clear to the extent that it's not clear from the record. The personal rating, like the academic rating and the extracurricular rating and the athletic rating, is a number that is put down by a, quote, first reader. That is, the file comes in, it's not usually complete, and just as a matter of triage, one of the 40 admissions officers goes through and gives these numerical numbers. The testimony was, it is not considered in any way once the subcommittees and committees meet. It, quote, fades into the background. It is not the basis of admissions decisions. And so not only did the court find as fact that that slight disparity was not evidence of discrimination, even in the personal rating, it had no effect with respect to outcomes.
It makes no difference whatsoever?
It's not that it makes no difference whatsoever. Look at what the expert testimony was, and I realize
Does it make a difference or doesn't it make a difference?
It doesn't make a statistical difference in admissions outcomes.
Then why do you do
both
it?
courts found.
Why do you do it?
It
doesn't matter. Why do you do it?
We do it as a matter of triage. Right now, Harvard is last year got 61,000 applications for 1,600 slots. And it is an entirely rational way of figuring out how you were going to allocate your attention to ask an admissions officer as the file is being developed, just go through in a very rough way and rate a particular application based on what you can see on these 4 metrics. The fact that Asian Americans got on average, a marginally lower personal rating score is no more evidence of discrimination against them than the fact that they got a marginally higher rating than any data can show on academics and extracurriculars. It doesn't mean that they're either smarter or people think they're smarter.
Thank you, counsel. We'll get to you in a moment. There's been a lot of talk about African American applicants to Harvard in sort of a general, indistinguishable way, when in fact they cover a very broad swath of applicants.
Of course.
What do you do with respect to an African-American applicant, I mean, you're concerned about diversity of viewpoint. Let's say his viewpoints tend to be very close to, the white applicants. He grew up in Grosse Pointe, had a great upbringing, comfortable. His parents went to Harvard. He's a legacy. And yet, under your system, when he checks African-American, he gets a tip. He gets a benefit from that. Isn't that very stereotypical under the Harvard program?
I think it's well, first of all, it is simply not the case that every black applicant gets a, quote, tip. In fact, I'll direct the court's attention to page 1,811 of the joint appendix, which includes this beautiful chart, which represents an undisputed model of the relative importance of race on application outcomes. And the one that you cannot actually even see to your far right is race. Race explains.
I can't see it because it's far away.
Nonetheless, you have the page
reference. It is not zero.
It is very close to zero. That is, the testimony in the case was.
Well, so there's only a little racial discrimination in the case.
Are you asking me whether Harvard is, you're asking me to answer a question that assumes that Harvard is discriminating on the basis of race? No, I can't accept that.
Well,
what Harvard says
isn't that what is, Mr. Waxman, isn't that what the case is about, the discrimination against Asian Americans?
There was count one of the complaint was that Harvard was intentionally discriminating against Asian Americans. The entire evidence of that case, all of the plaintiff's proof, was that Asian Americans are treated worse than white applicants. That is, that there was prejudice, intentional discrimination. The evidence could not more soundly have refuted that. What do you do with the charts?
What do you do with the charts in their brief? I think they're on page 24 or 43, the academic decile and the comparative treatment of African Americans, Hispanics, and Asian Americans. You don't see a surprising disparity in that?
So there's a lot to be said about that, but I guess the first thing I would say about that chart is that their own expert agreed that because that chart is simply a descriptive statistic, it is, quote, not equal to evidence of discrimination. It reflects a pattern which might or might not be real. Now, understand that that chart that they've displayed for you, they have eliminated all ALDC applicants. So 1/3 of the admitted class over 6 years, they're not even in that chart. That chart is predicated on something called an academic index. An academic index is a formula that looks at two things: high school grades and test scores.
And so people in the different racial categories, they have a different result based on other factors, which include race.
They have a different result because among the many, many, many characteristics of any particular individual applicant that Harvard considers, one that it does not consider is the academic index. That is the very metric that they're displaying for you. Harvard doesn't even use the testimony in the case was the only reason that the academic index is even calculated is because the Ivy League athletic rules require that your recruited athlete class, the AI for your recruited athlete class, not be more than 2 standard deviations below the matriculating class last year.
Put aside the hypothetical about the African-American applicant who's a legacy. Take 2 African-American applicants in the same category, however you want to take it. They both get, or both can get, a tip, right, based on their race. And yet they may have entirely different views. Some of their views may contribute to diversity from the perspective of Asians or whites. Some of them may not. And yet it's true that they're eligible for the same increase in their opportunities for admission based solely on their skin color.
So the point—
That was a question.
No, I know. I'm attempting to answer your question. There is no doubt that as the testimony showed, that for applicants who are essentially so strong on multiple dimensions, so extraordinarily strong on multiple dimensions, that they are sort of on the bubble, that they're a real candidate for admission, being African American, or being Hispanic, or in some instances being Asian American, can provide one of many, many tips that will put you in.
People say that, yes, but you will have to concede that if it provides one of many, then in some cases it will be determinative.
I do concede that.
Okay, so we're talking about race as a determining factor in admission to Harvard.
Race for some highly qualified applicants can be the determinant factor, just as being an oboe player in a year in which the Harvard-Radcliffe Orchestra needs an oboe player will be the tip.
We did not fight a civil war about oboe players. We did fight a civil war to eliminate racial discrimination, and that's why it's a matter of considerable concern. And I think it's important for you to establish whether or not granting a credit based solely on skin color is based on a stereotype when you say this brings diversity of viewpoint. It may not bring diversity of viewpoint in a particular case at all.
Well, number one, viewpoint diversity, while Harvard values it and seeks it, is not the only by far the only reason for wanting a genuinely diverse class. We want a diverse class for backgrounds and interests and lots of things other than just viewpoint. If we were to use, for example, the example that has been discussed, I believe, for every other advocate that has stood up this morning, and ask, what about taking race into account if the student writes about it? The fact of the matter is Harvard is attempting not to have among a class that is diverse among many generations, a class that is racially diverse only for people for whom their racial identity and their racial experiences is of such compelling importance that they write about it, right? Your hypothetical about the black student who may have very different views than the stereotype of what a black student will have is in fact the subject of that's discussed in the Corona report. The Corona report gave, in its analysis of the importance and dimensions of diversity, an actual example that came from Richard Light's book, published book, which had a particular class. It happened to have 3 African-American students in it. An African-American student gave an answer in a discussion, which another African-American student said, that is not my view. My view is quite the opposite. And a third one said, I wasn't actually going to say anything, but I have a completely different view. That was an incredible learning experience, not only for the non-African Americans in the discussion, but for them. And that's what Harvard is trying to get at.
Thank you,
I'm
Mr.
sorry
Waxman.
for taking so long.
No, I appreciate your answers. Justice Thomas? Justice Alito?
In Bakke, Justice Powell chose Harvard's admission program as a model, and that selection has had an enormous effect for the last 50 years. Harvard submitted a brief in Bakke along with a number of other colleges. So I went back and I looked at it and noticed that the brief talked about Harvard's program going back 30 years, but it didn't say anything about President Lowell or what Harvard had done back in the 1920s. So my question is, did Harvard sell Justice Powell a bill of goods? Do you think Justice Powell would have held up the Harvard program as a model, as an exemplar for the whole country, if he knew about the origins of the holistic program?
Justice Powell used Harvard's description about its admissions process and the limited extent to which it was then and for the past 30 years had been using race as one factor among many to achieve genuine diversity in its student body. The Harvard brief, Justice Powell didn't take it or not take it because prior to the Civil War, Harvard College was a leader in encouraging diversity in its undergraduate applications any more than the fact that it had a terrible stain on its history 100 years ago. It was taken for what it was presented as, and it fairly presented how the Harvard admissions process worked then and works now.
Justice Sotomayor?
Counsel, there are two questions that I want to get to that were asked of you. The first was Justice Alito's about the poor personal rating. It seems to me that petitioner claims that Harvard's discriminating against Asian Americans because it uses subjective criteria that's affecting the personnel ratings. That's how I think I read his question, correct? So it's not that it's using race in admitting people, it's that it's using a corrupted personnel rating, correct?
Well, I don't want to speak for Justice. I don't want to presume to speak for Justice Alito.
I agree.
think it is fair to say that the criticism of the personal rating
Right.
relates to the, quote, subjectivity that is involved really in all of the ratings, but particularly in the personal rating.
Well, the evaluations that use words like not a non-leader, not caring, not whatever.
Yes, yeah.
It applies to all races, correct?
Of course.
All races, applicants receive those ratings as well, correct? And I think what the expert was saying, the fact that you have these numbers, standing alone don't tell you anything, correct? You have to look at all the input that goes into why.
Correct.
Whether there was discrimination or not, correct?
Correct.
All right, so the numbers alone tell you nothing.
That's right. The numbers can tell you. You can tote up 100,000 applications and look at what the first reader scored and measure it against declared race and come up with a feature that says, gee, across these 150,000, or in this case, 150,000 minus all the ALDCs, it looks like, on average, self-declared Asian Americans have this number, and self-declared whites have this number. It tells you nothing about why that number was given any more than why.
And I don't want to cut you off, but I want to get.
No,
And so it doesn't tell you why, and there was no proof to show why. District Court found that that number did not prove discrimination. Correct?
There was actual proof that it did not reflect discrimination. There was expert analysis on multidimensionality, and that looked at the non-academic index that showed that, for example, white applicants who got a 1 or a 2 on academics and Asian Americans who got 1 or 2 on academics, for whatever reason, the latter group got lower teacher ratings than the former. And same with guidance counselor ratings. It doesn't tell you why. It doesn't permit, and it certainly doesn't permit an inference that Harvard is discriminating. The district court could not have been more definitive about the absence of any racial discrimination or discrimination against Asian Americans than it was. A finding that the Office of Civil Rights in the early 1990 also found.
All right, could you deal with stimulation D? I think that you were trying to explain why the district court rejected that simulation, numbers as meaningful. Could you finish your answer?
Yes, and in particular, I'll point the court to, because I'm not going to be able to do it as well as the district court, to pages 208 to 220 of the joint appendix, which is the district court's findings on this, and 73 to 79, which is the Court of Appeals, and 1307 to 1325, which is the Smith Committee's analysis of this. But basically, what the district court found was, as I said, that simulation D would require significant sacrifices, I don't have the quote right in front of me now, on almost every dimension that Harvard values, including a substantial decline. We're not talking about a decline in SAT scores or going from the 99th percentile to the 98th percentile. We're talking about the following things that the court found. the percentage of the matriculating class that would be academic 1s or 2s would go down by 17%. Every other factor would go down by at least 10%, between 10 and 22%. The number of matriculants interested in majoring in the humanities, which is a major tip that Harvard gives because of Harvard's recent inability to matriculate excellent students who want to major in the humanities, would go down by 14%. The number of African Americans admitted would go down from 14 to 10%. It was the whole confluence of all of those consequences that led the district court to confirm that it was not a workable, effective, race-neutral alternative.
Well, it seems that for Justice Gorsuch, none of those other things are compelling interest. And how do we respond to that? He would say,
I'm
it's
not
nice
sure
that
I'm
you-
ascribing that to Justice Gorsuch. But
Well, but he seemed to say an art museum is not important. So if the matrix shows that those interested in the arts falls dramatically, that might be of concern to Harvard. I think it's valuable.
It might
but-
very well be a concern. Would it lead a judge skeptically applying strict scrutiny to say, oh, it just doesn't work. You're not going to have an art museum, or you're not going to have a squash team, or you're not going to have, alumni contributions. It wasn't any of those things. It's a caricature to say that those were the reasons why this particular thing wasn't a race-neutral alternative. Now, I just want to say, if you think, notwithstanding the findings, that the district court and the Court of Appeals didn't properly apply the kind of strict scrutiny and narrow tailoring analysis that it should have, okay, that's a remand. I don't think the record will bear that out. It is not a reason to dispense with decades of constitutional precedent that has allowed all of these, what this court has properly considered to be a compelling national interest in having this kind of learning environment.
Thank you. Justice Kagan?
Mr. Waxman, there have been a lot of questions today, and I take these to be important questions about what is the end point. If we can achieve racial diversity through neutral mechanisms rather than through race-conscious mechanisms, we should. We've said that many times. So the question is, when can we say that we can achieve our racial diversity goals in that way? And I guess I have a two-part question, and then an assumption that I want you to bake into the two parts. The first is, what is Harvard doing in an ongoing way to test whether that is true? And the second is, does Harvard see any progress along that dimension? In other words, I think it was said by Petitioners' Counsel, oh, Harvard is doing, is putting is using as great a preference as it ever did. And the question is, over time, has Harvard found that it has become less necessary to use race-conscious means or not? Here's the assumption that I want to have you baked into this, which is I take petitioners to be saying, and I think that this is an important thing, that it doesn't matter if some part of the reason for adopting race-neutral approaches is to achieve racial diversity. I think that they very clearly said that. I'm not sure I understand why, given their legal arguments, but I think that they very clearly said that. So assume that you can, sit down and say, we're trying to figure out what race-neutral mechanisms to use, and part of the goal is to achieve racial diversity. What is Harvard doing to answer that question, and is it any closer?
I have firmly in mind the second part of your question. If I don't also answer the first, please remind me. The evidence in the case is that for decades, Harvard has been taking steps other than the conscious other than race consciousness, to increase the level of diversity, including ethnic and racial diversity. And these are discussed actually in the Smith Committee report and Dean Smith's testimony and in the findings. It, for example, in the wake of Grutter and actually before, substantially increased the amount of resources that it put in outreach, in partnering with organizations that that assist and advance the educational potential of minority and low socioeconomic students. It has achieved some success in getting additional applications, not just from minorities, but from minority applicants who are actually really qualified to attend Harvard. It thought about, well, maybe a way to increase this is to substantially increase our financial aid. And there's evidence in the case, there's actually a beautiful chart that shows how the level of financial aid went up at various points over 2 decades, and what happened with respect to the racial diversity of the applicant class and the matriculating class. And what the testimony showed and the findings was it made a difference to a point. After a certain point, it no longer made any difference. Harvard tested the proposition that its early action program, it's not early decision the way that most schools are because you're not committed to it, but that by admitting a significant percentage, I don't know, 20 or 25% of its class for people who applied, early on in the academic year, it was disadvantaging minority applicants and applicants from low socioeconomic circumstances because they didn't have the kind of resources, guidance counselors and test prep and all that sort of stuff to be able to take advantage of it. They ended it and asked other universities to do the same thing. With 2 exceptions, no one else did. And what they found at the end of 5 years was that it had the opposite result. That is, it made it more difficult for them to recruit and matriculate underrepresented minorities. And there were a bunch of other things in the record about things that Harvard has done, some of which have had substantial success. And so the notion that Harvard is doing things the same way and is always going to do the same things the same way is just wrong. Harvard completely recognizes and endorses this court's statement in Grutter that, quote, there are serious problems of justice connected with the idea of preference itself. That's why it holds itself, why it is attempting to achieve all of the compelling benefits of a genuinely diverse student body in the most race-neutral way that it can. And in terms of, I don't know if this is the first part of your question, but Harvard is actually measuring how it is doing in terms of diversity and the benefits of diversity and what needs to be done and what other things can be done in a race-neutral way on a very regular basis. And I can give you the data on, with respect to either, but for example, Harvard committed itself in 2018 that it would continue to look for race-neutral alternatives and have another systematic review, systematic, statistically, rigorous review about how it is doing. That committee has been formed and has already met for the 5 years that will transpire next year. Yes, we are trying. Yes, we have tried other things that have helped. Are we there yet? No, and that's the reason why the 45%, the district court's finding of 45%, that's what it shows. It shows.
Thank you, Mr. Waxman. Justice Gorsuch?
Yeah, I just was hoping to get an answer to the second half of the question, which was when does Harvard anticipate this will end? Grutter spoke of it being a 25-year window, as you're well aware. Harvard could tomorrow do without federal funds and continue to discriminate on the basis of race however it pleased. I'm sure that would be a hardship. But what is Harvard's view on how long this will take?
So Harvard like the Solicitor General and like UNC, understood all 4 paragraphs of what Justice O'Connor wrote in her opinion and takes it to heart. What Justice O'Connor said was, it's been 25 years since Grutter. There's evidence that our society is changing. We expect that 25 years from now, the use of racial preferences will no longer be necessary.
So Harvard agrees with that?
And
does Harvard agree with that?
Harvard does not currently, based on its data, expect that in 2028 it will have been able to use only race-neutral alternatives. But what I do agree with, if I may,
it's a real simple question. If Harvard doesn't have an answer, that's fine. But does Harvard have some view about when?
Yes, Harvard's view about when doesn't have a date on it. Harvard takes to heart Justice O'Connor's opinion that, quote, in the context of higher education, the durational requirement can be met by periodic reviews to determine whether racial preferences are still necessary to achieve student body diversity. And we want to be put to that strict scrutiny test.
Thank you.
Justice Kavanaugh?
I do have 2 or 3 questions. First, you're seeking educational diversity, as I understand it, at Harvard. But my understanding, correct me if I'm wrong, is that you don't ask about religion and why the disparate treatment of religion and race. Why would evangelical Christians, Catholics, Muslims add to the educational diversity at Harvard and other religious groups? Added the diversity, and why not ask about that?
So Harvard greatly values religious diversity. It is extraordinarily proud of the religious diversity.
How can it track it if it doesn't ask about it?
Oh, how can it track it?
How can it track it in the admissions process? May happen by happenstance. I'll let you finish.
Okay, Harvard is not tracking it in the admissions process other than to the extent that, and many students indicate what their religion is. Harvard has not thought it necessary, and so far as I know, nobody has suggested that Harvard has any need to provide a tip for religious diversity because the Harvard undergraduate population is so religiously diverse. There are currently 47 chaplains.
That answers my question.
Yeah.
Okay.
I just want to say that our ministry ministers to 27 different religious denominations.
Right. It was a factual question. Second, I think you agree that the baseline in our precedents, operating within the confines of our precedents, as you want us to do, is race neutrality. And we've allowed, though, limited consideration of race in higher educational admissions. As you've heard, 2 limits on that, as I understand it. 1, the adequate race-neutral alternatives. 2, the durational limits, the 25 years or whatever durational limit you think works there. I just want to make sure you agree with how I set that up. In other words, race neutrality is the baseline. There are 2 limits on the consideration of race-conscious educational admissions at colleges and universities. Adequate race-neutral alternatives would be 1. A durational limit, 25 or something else, would be the other. Is that how you read our precedents?
I read your precedent in that. I think you have other requirements too, which is it has to be flexible, it has to be one factor among many, et cetera, et cetera.
Right.
But I agree with your 2 categorizations, except that with respect to the durational requirements, we understand it to be consistent with the language from Justice O'Connor's opinion that I quoted the court, which is that the narrow tailoring requirement and the race-neutral alternative requirement, strictly, scrupulously, and skeptically applied, will tell us when race-neutral alternatives.
Okay, and one last one. This picks up on Justice Kagan's and Justice Gorsuch's questions, I believe. But on the adequate race-neutral alternatives question, it seems that Harvard would have to sacrifice potentially something else to achieve what you think would be meaningful, sufficient racial diversity. And I think the questions, Justice Gorsuch, were, well, why don't you have to then sacrifice those something else's to achieve the if you're going to otherwise use race-conscious means.
And there's no question that
in other words, I think that's a legal question we're going to have to ultimately figure out. Does a university have to sacrifice those other things or not?
And so what this court's precedents say, Bakke, Grutter, and Fisher are, of course, there are race-neutral alternatives that may require some sacrifices. A university is not required to sacrifice, so much that it changes the essential character. I wish I had this court's own words, but I think that's the test, and that was certainly the test the district court applied.
That suffices, and you answered it. Thank you.
Thank you.
Justice Barrett?
Mr. Waxman, this is not a question about Harvard's history of anti-Semitism, but I do want to go back to the opinion in Bakke and Justice Powell's holding up Harvard's application process as a model. And then Justice O'Connor and Grutter again referred back to Harvard's admissions process. And I want to know whether Harvard's admissions process has meaningfully changed from the time that Justice Powell held it up. I mean, what Justice Powell found attractive about it, what Justice O'Connor endorsed, was the holistic aspect of it, and that race can be used as a tip. In its essence, is it the same?
Yes, race can be used as a tip, as one of many, many, many tips in an effort to achieve diversity that is across many, many dimensions beyond ethnic.
And so in the way that Harvard thinks about its admissions process, it is the same now as it was in Bakke.
Yes, Harvard is, can I just give one sentence explication of that? What the Harvard Admissions Committee is attempting to do with the benefit, the luxury of a pool of applicants that is supremely qualified, is to bring together a class of 1,600 matriculants who are best, in the judgment of the admissions committee and the faculty that oversees it, are best able to learn from and teach each other as an organic whole.
So my question is, we've been talking a lot about endpoint, and my question is, so Bakke was, almost 50 years ago now. If Harvard's admissions process is essentially the same in the way that it accounts for race and thinking about endpoints, and I recognize and you describe some of the things that Harvard is doing to try to recruit more minority applicants, but why are we to think that there will be an endpoint? And Grutter's pretty insistent. I mean, Grutter says the requirement that all race-conscious admissions programs have a termination point. So there has to be one, and if it really hasn't changed much since Bakke.
So the system, that is, we're taking race into account as one factor among many. Obviously, the extent to which race qua race is a factor is dependent on the extent to which so-called race-neutral alternatives have already helped Harvard to matriculate a class that is diverse along this dimension and others. And Harvard does track its progress in this regard and accommodate the admissions process. For example, in terms of where we are, when will we get there? The record contains, any number, a faculty committee study, a working group, a task force, all of which made reports about this, but it also annually does a comprehensive survey of its graduating seniors and asks them questions that go to this. And the survey and the record on the benefit side, I think to Harvard's great satisfaction, showed that 2/3 of all of the seniors said that their Harvard experience strengthened their ability to relate to people of different races, nations, and religions, and 70% said that Harvard's experience had led them to seriously question or rethink their beliefs about a race or ethnic group different than their own.
But that's showing the educational benefits of diversity, right?
And it shows that in terms of, are we there yet? We're not going to achieve 100%. Honestly, 70% is pretty darn good. And it would not have been, at the time that Harvard wrote its brief in the Bakke case and at the time that Grutter was decided, those were not the statistics.
So you think you're getting closer to a termination point?
We are very definitely getting closer to a termination point, both in terms of engineering race-neutral alternatives, but also achieving a class that is diverse across religious, viewpoint, racial, ethnic, academic, political. Yes, we are proud of the progress we made. As Dean Smith said, we still have work to do, including with respect to the way in which we treat students and allow students to interact with each other once they get here.
Okay, thank you.
Thank you.
Thank you, counsel.
Thank you.
General Prelogger, welcome back.
Thank you, Mr. Chief Justice, and may it please the court. The court has heard hours of argument on the constitutional issues in this case, and so I would like to take a step back and focus on the profound consequences of the court's decision here for the nation that we are and the nation that we aspire to be. Petitioner seeks a sweeping ruling that would harm students at schools and colleges throughout the nation. A blanket ban on race-conscious admissions would cause racial diversity to plummet at many of our nation's leading educational institutions. Race-neutral alternatives right now can't make up the difference, so all students at those schools would be denied the benefits of learning in a diverse educational environment. And because college is the training ground for America's future leaders, the negative consequences would have reverberations throughout just about every important institution in America. For the United States military, as I've explained, having a diverse officer corps is a critical national security imperative. For corporate America, diversity is essential to business solutions. For the medical community and scientific researchers, diversity is an essential element of innovation and delivering better health outcomes. Overruling Grutter would have devastating effects on our nation's efforts to move ever closer to a more perfect union where our nation's diversity is a source of its greatest strength. And I think the court should not take the destabilizing step of overruling precedent here. Justice Gorsuch, you asked a series of questions about race-neutral alternatives, and I want to offer the position of the United States. I think, Justice Barrett, you also asked these questions about things like legacy, donors, children of faculty and staff. And I want to be very clear on behalf of the United States that if it could be shown that eliminating those kinds of preferences would actually enable a university to meet its diversity goals and to be able to offer the educational benefits of a diverse student body, then yes, we think absolutely that can function as a race-neutral alternative. And it's incumbent on universities to consider those kinds of options as they chart a path forward. And so I think to the extent that the court has any concerns about that or thinks that the lower court in this case did not apply that kind of standard, that would be wrong, because the court has made clear that strict scrutiny in this context is strict, and that universities have to undertake continual obligations to search for those types of alternatives in order to be able to achieve diverse student enrollment without taking race into account.
Grutter was about college admissions, but in your opening statement, it seemed to me you want to extend it to employment. Is that right?
No, Justice Alito, I was trying to make the observation that the experience of students in those 4 years of college have effects on the course of their life.
Then why were you talking about corporate America?
Because corporate America, like the United States military, relies on having a diverse pipeline of individuals who had the experience of learning in a diverse educational environment and who themselves reflect the diversity of the American population. We're not asking the court to extend Grutter in any way here. We're only asking the court to reject petitioner's request for the court to overrule that precedent, because I think it would have these destabilizing ramifications in just about every important industry in America.
General, if we were talking about the 25-year mark, so let's imagine we fast forward and it's 5 years from now and we're considering whether to, same question, would it be overruling Grutter at that point to say this is the end point, we're at 25 years, no more race consciousness in admissions?
I think it would if this court based that decision on the nature of the compelling interest here. I just don't think it's a tenable way to read Grutter to say that the court was suggesting that 25 years from now, poof, the interest in diversity in higher education is no longer compelling. That is and will remain a compelling interest. And Grutter observed that over time, it would be possible for schools and universities to achieve that interest without having to take race into account. And I understand the concerns, Justice Barrett, that you've raised, Justice Kavanaugh, that you've raised about the fact that the arc of progress in society has perhaps been slower than the Grutter court imagined. I think if this court has those concerns, it could emphasize that the narrow tailoring requirement remains very strict in this case. Universities should be held to a high standard and a heavy burden to explore those alternatives, to put into practice the race-neutral alternatives that currently exist, and to try to get to the point that the Grutter court imagined and that we will eventually reach as a nation where it is no longer necessary to take race into account.
But what if the structural barriers, I mean, there's not a remedial justification on the table here. Our precedents rule that out. What if the structural barriers just make it impossible 25 years from now to sit here and say that without race-conscious admissions, you know, especially if Harvard wants to keep everything exactly the same with respect to its other metrics like SAT scores not dropping at all and the museum and the squash team and all of that stuff. What if it's just impossible? And so what if Grutter was grossly optimistic in what it thought was achievable, and perhaps, you know, Grutter, as we've talked about earlier in the argument, emphasized the risky and potentially poisonous nature of race classifications. What if there's no endpoint? I mean, could we still say that there's a compelling interest in the educational benefit of a diverse classroom if it comes at the cost of something that Grutter itself recognized was very dangerous and corrosive to society?
I do think that, yes, the compelling interest would still exist there. I recognize the force of the point that there are structural barriers that can impede progress, but I think it would be wrong to suggest that those barriers are going to exist in perpetuity in all places and with respect to all schools. The states are not similarly situated in this regard. There are 9 states, as petitioners emphasized, that have barred the use of race in college admissions, and many of the universities and colleges in those states have been able still to achieve enrollment of diverse student bodies. And I think that it's incumbent on every college and university around the nation to study from and learn from those examples. And it's not accurate to say that if we look forward into the future in 25 years, still at all places throughout the nation, it will be necessary to have race-conscious admissions. But I do want to be responsive as well to the point that you made about resisting any changes whatsoever, and be clear again on behalf of the United States that we do not think that a university could reject a race-neutral alternative because it would have those kinds of modest impacts on things like SAT scores. I think that that can clearly be the kind of thing that would qualify as a viable or workable race-neutral alternative, and if the court has any concerns that lower courts are not applying that stringent standard, then I would urge the court to make that clear in a decision and provide guidance going forward.
I think that's very important, what you just said. So you're saying an adequate race-neutral alternative, it would be permissible for the court to say that you have to eliminate things like legacy, children of donors, if you could obtain a sufficient, meet its diversity goals, was your word, by doing so and doing race-neutral admissions. Do I have that correct?
Yes, that's exactly right, Justice Kavanaugh, and I think that that flows directly from this court's
But I'm
emphasis.
sorry, at what point does that become dramatic? Harvard won't be Harvard if it drops from 2,200 to 500.
Yes, and I was speaking.
Or there is a point at which a change is significant or insignificant.
I agree, Justice Sotomayor, and I think that the lines that the court has drawn in this context flow from Grutter itself, where the court made clear that a university doesn't have to sacrifice its reputation for academic excellence. In other words, it doesn't have to accept those kinds of dramatic changes to the academic quality of the incoming student class. I was speaking
Well, your adversary on Simulation D says the change was only from, it was less than a 40-point change, and so he says that's insignificant. Why do you think his point is not valid.
With respect to Simulation D, in particular, it wasn't just changes to SAT scores. I think the most substantial reason that the district court rejected that as a workable alternative here is because it would have had a precipitous decline in the number of African American students. They would fall by about 30% in the enrollment of the class, and that was coupled with the impact on reductions in the number of students who had the highest academic and extracurricular ratings who could then be admitted in the class. But I
So
don't...
you're sacrificing the essence of Harvard, academic excellence.
That was what the district court found with respect to Simulation D. But, you know, I guess I would say I think that that was a factual finding in this case. The First Circuit affirmed it. But as Mr. Waxman said, if you do not think the district court applied the right stringent standard in evaluating that as a race-neutral alternative, then that is a basis to send this case back, because we agree that strict scrutiny is strict in this context.
The other side points to the examples, as you've heard, throughout of California and Washington, Michigan and Florida and other states, and says, well, if they just put their effort to it, they will be able to use race-neutral alternatives and still be able to achieve its diversity goals. I'm going to bracket the fact that its diversity goals is still pretty vague, but we talked about that in the last case, but would still be able to do so. You want to respond to that?
So as I was saying to Justice Barrett, I do think it's the case that there are some states and certainly some institutions today that can fully achieve a diverse student body without needing to take race into account. With respect to California and Michigan in particular, since your question referred to them, I would point the court to the amicus brief filed by those university systems in those states, which have explained that actually they have struggled, despite implementing any number of race-neutral alternatives, to actually see true diversity across all of their campuses, including their most selective campuses. And University of California in particular points to Berkeley and UCLA as places where there have been these dramatic declines in diversity, racial diversity on campus.
I guess this will be repetitive, but you've said true diversity, meet its diversity goals. You know, I'm not sure exactly what that means, and that's we're going to have to figure that out, I guess. But without any more precise guidance on what exactly meet its diversity goals means as to numbers, it's a little hard to assess, I think.
Well, let me try to be more precise. I think that the relevant compelling interest here comes directly from Grutter, where the court recognized that it is student body diversity in all of its many manifestations. The court has made clear it's not simple ethnic or racial diversity, and that's what creates a lot of the guardrails in this area in terms of no racial quotas, no automatic awards of points, no separate set-asides or separate admissions tracks. The nature of the interest is not in achieving a precise numerical threshold of minority enrollment at a particular university. Instead, the court has defined this as the educational goals that derive from having a diverse student body along multiple dimensions. And that is the ultimate aim of these policies.
So a university that did use a numerical goal or did grant a tip based on race alone would be a problem.
Yes, I think if a university used a numerical goal and that functioned as an inflexible goal for the university or functioned as a quota system, that's plainly unconstitutional. This court's precedents don't countenance that.
And when we look at that, I'm sorry to interrupt. Go ahead and finish.
I just wanted also to try to be responsive to your point about using race as a tip or a preference, and to be clear that there as well, the court has made clear that that can't be mechanical application, so you can't preference every single person automatically or inflexibly.
Okay. And but what is a court, a lower court, all right? I mean, faced with diversity and very hard standards to apply, supposed to do when a university's admissions data with respect to race looks more or less identical every single year?
So I think at that point, the district court needs to probe whether impermissible racial balancing is happening. The court has made clear that that is not appropriate, that the relevant compelling interest here is not in trying to achieve a precise percentage of particular racial or ethnic groups in the class year over year. And so if that kind of evidence existed, then I think it would be incumbent on the university to establish that it is not actually engaging in racial balancing.
Thank you.
I think in this case, wasn't it clear there were variations among the groups?
Yes, that's
overall?
exactly right, Justice Sotomayor. And what the district court said with respect to the Harvard facts is that there were greater fluctuations with respect to the number of students in each group who were admitted year over year than there were fluctuations in the applicant pool of individuals of those particular races. And so the district court said that runs completely contrary to a theory of racial balancing in this case.
Now, going back to the earlier argument, Petitioner's counsel in rebuttal raised Berkeley's figures, and I don't remember it exactly, but it was like a third white, a third Hispanic, a third this. At the end, he mentioned a black population that seemed tiny. But how do you deal with answering Justice Kavanaugh's question of what constitutes adequacy? Because he seemed to imply, your opposing counsel, that that Berkeley was already diverse. It had numbers that were close to the population.
Well, Justice Sotomayor, I would point to the brief filed by the University of California system in this case, and they have explained in detail how Berkeley has experienced a substantial decline in the African-American student population. I think it's gone down to 3%, and they further have explained the toll that's taken on their ability to offer the educational benefits of diversity, as well as the glaring sense of racial isolation that those students have on the Berkeley campus.
Thank you, General. Justice Thomas? Justice Alito? Justice Kagan?
General, one of the through lines of the briefs in this case is, I think it's actually the first line of the petitioner's brief or something like it, is essentially Brown compels the overruling of Grutter. And the petitioners actually haven't given a whole lot of attention to that argument, but the idea is, and some of the questioning has reflected this idea, is that we have this long and horrible history of racial discrimination, and surely that functions here to prevent racial classifications or to prevent race consciousness of the kind that Harvard and UNC are using. And I just thought I'd give you an opportunity to discuss what you think of that argument.
I think that argument is wrong in just about every respect. There is a world of difference between the situation this court confronted in Brown, the separate but equal doctrine that was designed to exclude African Americans based on notions of racial inferiority and subjugate them, which, as this court recognized, with school children affected their hearts and minds in a way unlikely ever to be undone. A world of difference between that and the university policies at issue in this case, which are not intended to exclude anyone on the basis of race or even to benefit particular racial groups on the basis of race, but rather are designed to bring individuals of all races together so that they can all learn together and benefit from that diverse educational environment. And I think it is profoundly ahistorical to say, as petitioners do, that those situations are precisely equivalent, and it also trivializes the grievous moral and legal wrongs of state-sponsored segregation and the enormous harms that millions of Americans suffered under it.
Justice Gorsuch?
Just to return to Justice Sotomayor's question to you, you indicated, I believe, that the percentages have varied dramatically over the years. I must be missing something. On page 23 of the petitioner's brief, they have the statistics from Harvard from 2006 through 2018, and the share of Asian American students varied between 17 and 20% every year, 70% actually being the outlier. Am I missing something?
No, Justice Gorsuch, I think that the point I was trying to make is that that band is actually a greater amount of fluctuation than was present in the applicant pool with respect to the number of Asian Americans who were applying to Harvard every year. But let me just say this.
Is the same thing true with the Hispanics and African Americans? Because the numbers are pretty similarly banded for those.
Yes, that's my understanding, that the district court's factual finding in this regard is that there was relative stability with respect to the number of individuals in those groups who were applying and greater fluctuation with respect to admissions decisions.
No, these are admitted students I'm talking about here.
Yes, and the district court was drawing a comparison between the bands that you were just describing and the bands that exist.
But the point is, whatever the pool is, every year the percentage is the same. And the U.S. government below said this manifest steadiness speaks for itself. Am I missing something?
Well, let me just say that the district court made a factual finding of no racial balancing. But if you think the district court was wrong about that and this is clearly erroneous, then that is clearly impermissible and the court should send it back. That would provide a basis to reverse on clear error, and we are not here to suggest that racial balancing is okay under this court's precedents. Grutter doesn't countenance it, and the court could make that clear.
Thank you.
Justice Kavanaugh?
I appreciate your statement about Brown. I want to ask a question. Justice Thomas's opinion in Grutter said, I agree with the court's holding that racial discrimination in higher education admissions will be illegal in 25 years, end quote. And taking that statement, it would seem that extending it beyond 25 years would itself be overruling Grutter. And just want you to have a chance to respond. Is that not an accurate characterization of the court's holding in your view, or what is your response to that description of what the court did? Variation on questions you've had before, but I wanted to give you an opportunity to address that in particular.
I do think that is not how the court itself understood the language. The court made clear in the 4 paragraphs that we've been discussing that the court expected that universities would no longer be able to justify race-conscious admissions policies over time, but that was because the court expected that due to the rate of change in society, they would be able to achieve the benefits of student body diversity without taking race into account. And so I don't think that it's tenable to read the majority opinion in that case as having determined that there was a 25-year clock that would be inflexible. Instead, it was an expectation about what changes we would see in society.
Thank you.
Justice Barrett? Thank you, General. Rebuttal, Mr. Norris?
Thank you, Mr. Chief Justice. Just a few points. First, I think what's lost in the United States argument, in Harvard's argument, and in Grutter itself is that racial classifications themselves have harms. They stigmatize their intended beneficiaries. They increase racial consciousness, which delays the day in which we can move to true racial neutrality. And they cause resentment by treating people differently based on something they can't change, that's cosmetic, and that's irrelevant to their ability to get educational opportunities. The court said that in Adirond. It said it in Shaw. It said it in Croson. Harvard doesn't challenge any of those precedents. Secondly, race-neutral alternatives. There were a few pleas for a remand that I heard from my friends, but it's hard to take those seriously when Harvard thumbed its nose at Grutter for 14 years to not consider race-neutral alternatives one time until 3 years after we filed a lawsuit against it. I understand Mr. Waxman to say he'll no longer defend his legacy preferences, but now what's at stake in terms of race-neutral alternatives are a slight decline in profile ratings, which Mr. Waxman said are not that important to the admissions process when he talked about Asian Americans, a 3 percentage point decline in people who want to major in the humanities. Students change majors like they change socks. I mean, speaking from experience, there will be people who think that they're going to major in the hard sciences, then find themselves majoring in the humanities. That's not the stuff of strict scrutiny. Then we have the 4 percentage point decline in black admissions. Our expert testified without contradiction that that is an absolute floor, that Harvard could get that number almost to parity if it considered wealth instead of income. And Harvard already sacrifices on all of these metrics in order to meet its racial goals. It should do the same for racial equality. This court made schools close to comply with Brown, as it should have. Harvard should have to sacrifice for the same reasons. Lastly, Harvard thankfully does say it is ashamed of its history of Jewish discrimination. I hope someday it says the same about how it's treating Asians. It is undisputed that Harvard, there's a statistically significant relationship between being Asian and getting a low personal rating, which is supposed to measure things like confidence, likability, and kindness. Harvard's witnesses consistently testified that Asians don't deserve lower personal ratings in their experience. Harvard didn't submit a model of the personal rating itself, which means I think they probably did study it and then realized they couldn't get rid of the disparity. And the model, when you take the personal rating out of an admissions model, it shows a statistically significant disparity against Asian Americans in admissions decisions. Now, the district court said, I believe Harvard that it doesn't discriminate, but we don't typically let people satisfy strict scrutiny with just their testimony. Mr. Waxman said it's attributable to unobservables in the model, but unobservables is code for the Asians really deserve it. And that's simply not true. That was not ever supported by any evidence in the record. And we keep saying Asians. These are not Asians. They're not from Asia. These are people who are Americans. They were born in Texas, California, Ohio, Tennessee. They should not be the victims. They were born in 2005, the people who are applying to college now. They should not be the victims of Harvard's racial experimentation. Thank you.
Thank you to all counsel in both cases. Case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.